Please welcome to Crime and Justice, True Crime Sleuth. Thank you for joining us today. Whoever is joining us, thank you very much. Please say hi. I am your host, Brian P. We'll be watching. The first thing we'll be watching is the Alex Murdaugh thing. Murdaugh. So it's up to you guys. If you want to follow, please like and subscribe. Status. It's really bad. Hi, Sean B. You just got here. Thank you for joining us. Please share this to all your friends. That's true. Can you hear Sean B? Can you hear me? Thank you. Can you hear the video as well? Please like, share, and turn on your notifications so you can know every time I start. Yeah, I don't know why it's doing that. I think they're trying to fix it. This is where I have to start right there. Right now. Anytime.
Kelly, allow me to use both of his hands, please.
We are.
Thank you. This is a pre-hearing procedure in the matter of state against Richard Alexander Murdaugh. It's case numbers 2022 GS 1500592 through 00595. Defendant Murdaugh was indicted for the murder of his wife, Margaret Branstetter Murdaugh, and his son, Paul Bennett Murdaugh, and related weapons charges. His trial began on January the 23rd, 2023. The presiding judge was Clifton Newman. After 6 weeks of trial, on the evening of March 2nd, 2023, the jury returned a verdict of guilty on all 4 indictments, on which the defendant was sentenced on March 2023 to 2 consecutive terms of life imprisonment. Notice of appeals of his convictions and sentences were filed by defendant Murdaugh's attorneys on March the 9th, 2023 with the South Carolina Court of Appeals. The transcript in this very lengthy trial took several months to produce, even in draft form. Before the attorneys received the final transcript, on September the 5th, 2023, defendant filed with the Court of Appeals a motion to suspend his appeal and for leave to file a motion for a new trial with accompanying affidavits and transcript experts. After further defense and state filings on October the 17th, 2023, the Court of Appeals granted appellant Murdaugh's motion to suspend the appeal and to remand this case to the circuit court to allow defendant Murdaugh to file a motion for a new trial. On October the 17th, 2023, defendant Murdaugh received the final trial transcript and very shortly thereafter filed a motion for new trial in the Colleton County Clerk of Court's office. Subsequently, Judge Clifton Newman recused himself from further proceedings in this matter. On December the 16th, 2023, on December the 18th, 2023, Chief Justice Donald W. Beatty signed an order appointing or directing that the Honorable Jean Hayford Toll, retired Chief Justice of South Carolina, be assigned exclusive jurisdiction for the limited purpose of presiding over defendant's motion for a new trial. I promptly contacted counsel in this case and set deadlines for briefing and arguments of the new trial motions. The new trial motions were set to be argued on January the 23rd, 30th, and 31st of 2024. And after several rounds of pretrial briefs having been submitted to me, I also set today's date for a procedural pre-hearing. Before I begin, may I say that we certainly welcome members of the media, and I thank publicly Attorney Jay Bender for agreeing to be the voluntary media coordinator for this matter, as he did for Judge Clifton Newman on the trial of this matter. Cell phones are normally not permitted at all in our courtrooms, but the press has been allowed to bring in certain cell phones and laptops and electronic devices because of the non-jury nature of this portion of the proceedings. But if any device rings or sounds to receive a call or to receive an email or a message, that device will be confiscated and the owner will be asked to leave the courtroom. So please now, if you haven't already, check your electronic devices and be sure that they will not sound during the time these proceedings take place. Major topics to be covered today have been addressed by me and discussed with counsel in a short pretrial conference in my chambers. And counsel may have certain things that they will put upon the record as we proceed through these topics that deal with what should be covered. The first topic is an evidentiary hearing necessary at all? The state took the position that the answer to that was no. Obviously, the defendant not. I have set an evidentiary hearing because I felt like we had to have some brackets on the time we would spend on this matter. But I've made no conclusive decisions beyond that on matters affecting the arguments the state makes about the procedural posture of this matter. The next topic would be the burden of proof. Who has the burden of proof in this matter? And what must be shown to meet that burden of proof? And what must then be shown to contest what has been shown and proved? The third topic is procedural defects, most specifically a contention by the state that this motion is untimely because of what was known before a verdict was rendered, accepted, and the jury polled. And finally, we need to discuss witnesses, juror witnesses. The Clerk of the Court of Colleton County is Hill, and other witnesses and exhibits. I note that at least one attorney in the room is an attorney for some of the jurors, and other jurors may have other attorneys. When I get to the portion of this discussion where we talk about specific witnesses, and if I am asked to hear from attorneys for the witnesses, I will at least consider that request. I don't know where we will be at that time in terms of what has been decided. But I would at least inquire about that. To that end, if you have not already, during the first break, be certain that all of you, the lawyers participating at council table, and any other lawyers that feel they may have some interest in the proceedings that would warrant comment by them, please give your cards or information about your contacts to our court reporter, Ms. Harris. With that, Mr. Harper, being your moving party, you may proceed.
If it pleases the court, Your Honor, you've raised, I assume you want to go in the order in which you just.
I would.
Okay. You've raised a number of legal issues from whether we've waived, I forget the order in which you just took them. But Mr. Griffin is going to address those in seriatim based on what you said just a moment ago as to the witnesses and the jurors. I will be handling that portion of the argument today.
Very good. Mr. Griffin, we'll hear from you now.
Yes, thank you, Your Honor. The first issue that you've asked us to address is an evidentiary hearing necessary? And the answer to that question is very straightforward, is yes, under established case law in the Supreme Court, the Fourth Circuit, and the South Carolina Supreme Court under Reamer. A Reamer hearing is absolutely necessary where there has been credible evidence presented that there's been improper third-party contact with the jury prior to their deliberations that frankly, whether it goes to the merits or not, a Reamer hearing is absolutely necessary. And we believe that the Court of Appeals decision in this case contemplated a Reamer hearing. And in a Reamer hearing, evidence is presented as to what outside influences, if any, were brought to bear upon the jury. We have, in our motion for a new trial, submitted affidavits of one deliberating juror, one alternate, and then another affidavit of a witness to an interview of an alternate, and all three statements are consistent, and in that they heard Ms. Hill, the clerk of court, prior to deliberations, and frankly, before the defense put on their case, Ms. Hill instructed, do not be fooled by the defense. That's what the sworn statements say. And secondly, before Mr. Murdaugh took the stand, Ms. Hill advised one deliberating juror and two alternates, at least, watch his demeanor, which is an implication of, he's going to lie. And so then the question becomes, factually, did those contacts happen? And then, we proceed from there as to what the burden of proof is after that. But the threshold, are we entitled to evidentiary hearing? The law is crystal clear that we are.
Thank you, sir. Mr. Waters, to the state.
Thank you, Your Honor. May it please the court. Your Honor, obviously, you've addressed the issue of whether an evidentiary hearing is necessary. The state certainly understands that. It is incumbent upon us, though, based on the law, to preserve our arguments as to procedural bar, and those are twofold. And the first one, of course, is that a motion for a new trial must be filed within 10 days of the verdict, unless there's after discovered evidence. And I think an initial inquiry that needs to be determined is when the defense first learned of these particular allegations. In conversations with the defense, and they said they're going to give me an answer, that they may have had conversations with juror 785 prior to her being represented, which was only a couple of days after trial. So if that is the case and they were aware of these allegations, then we would want to argue to Your Honor and preserve the issue that this is not after discovered evidence and that there's a procedural bar in that regard. Secondly, we made the argument that the affidavits on their face, the only deliberating juror indicated, and that's 630, in that affidavit only said that she voted guilty. She had questions, but voted guilty because she felt pressured by other jurors. And of course, the law is crystal clear in multiple cases that sort of internal debate, it's actually in Rule 606B, that's not any sort of misconduct or anything that is a appropriate venue or mechanism in order to attack the verdict. So for that reason, we've argued that their showing in their motion for a new trial is insufficient based on the case law for an evidentiary hearing, because there is on its face no sufficient allegation of prejudice. That being said, of course, we fully understand and expect the evidentiary hearing to go forward, and we'll be happy to address burden of proof after the defense makes their arguments.
Very good. With respect to, well, Mr. Griffin, anything in reply?
Your Honor, it does not appear that the state, takes a position contrary that a Reamer hearing is required. They're arguing that we have sort of waived the right to that hearing. There's no evidence in the record of that. I can assure the court, we did not know of this information within 10 days after the trial. And when we learned of it, we promptly acted.
Well, in conversations with Mr. Arpulli and Mr. Griffin, they were going to actually look into that and look at their paralegals notes. So I fully rely on and trust the defense to give me a fair answer to that question. And then again, if there's an issue to be raised, we would raise that. We're not conceding anything. We just wanted to preserve our procedural issues.
I don't think we need to go back and forth many times about this. I think I understand your position. Here is my position on the matter. First of all, I am not conducting a Rimmer hearing. Rimmer is a 1954 decision of the United States Supreme Court that deals with the question of influence of the jury and a motion for a new trial on the basis of after discovered evidence of that influence. I rely on the South Carolina decision of our Supreme Court authored by Justice Kittredge, State versus Green. And the Green decision specifically says that Rimmer is not the guidance that South Carolina
I think we're going to retrial.
should look to
And then I happen to mention
conducting hearings on after discovered evidence. Now, that says nothing about what the burden of proof should be, and I don't intend to say anything thereby. But I do intend to tell you right away that I will be relying on South Carolina's jurisprudence and South Carolina's jurisprudence specifically on what must be proved in a hearing of this nature and who bears the burden of that proof. All right. And that leads to the very next topic that we'll now take up, which is the burden of proof. Mr. Griffin?
Yes, Your Honor. As we cited in our papers, we believe that the controlling case in this instance, based on the scope of conduct as alleged, and that is conduct of a court official here at the Clerk of Court, having communication with the jury about the substance or the merits of the case, that the standard to be applied is not Green, because Green, Judge Kittredge says that the contact by the bailiff was about a procedural issue, not about the merits of the case. Here we're dealing specifically with the merits of the case, and the Court of Appeals decision in State v. Cameron, we believe, is the controlling standard. And in State v. Cameron, and that was decided in 1993, and the court says, in citing Holmes v. United States, which is a Fourth Circuit opinion, says in this case there was a private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. No, we strongly believe that is the standard. Is the question of, was the subject matter of the communication harmless, and that it could not have affected the verdict. And that's our position on the standard. Your Honor, if Your Honor looks to a different standard, State v. Green, the measure of State v. Green, you can't look just at Justice Kittredge's opinion. You have to look, because he complimented the Court of Appeals decision. And the Court of Appeals decision absolutely applied the Reamer standard of the burden of production is on the defendant, but when the defendant produces evidence of a substantive communication to the jury by any third party, that's what Reamer is, by any third party, that then there's a presumption of bias, and that the state then has to overcome that presumption, produce strong, clear, and convincing evidence that it was harmless. And that was the standard that the Court of Appeals applied to State v. Green. And in State v. Green, the Court of Appeals says that this is the standard of the Fourth Circuit, and we follow the Fourth Circuit law in this area. Now, Justice Kittredge says that the communication by the bailiff, which essentially said, if you're deadlocked, which they never were and never became deadlocked, then the judge may ask you to stay locked. I mean, that was the communication by the bailiff in Green, and Justice Kittredge says that did not go to the merits of the case. Justice Kittredge didn't throw out the Reamer presumption standard in State v. Green, Your Honor. And it's important, the Court of Appeals decision looking to the Fourth Circuit, because, as Your Honor knows, urge the court to look at the Holmes decision out of the Fourth Circuit, which we cite, which applies Reamer. It applied Reamer in a habeas corpus case when they said Reamer is the clearly established law in the Fourth Circuit. And it vacated a death penalty conviction out of North Carolina because the North Carolina courts did not follow Reamer. And so the Court of Appeals decision in Green says we look to Reamer. Justice Kittredge says, we're not going to apply the Reamer presumption here because it didn't go to the merits. What we have in this case, and what we have, presented through proffer on the affidavits, something that goes to the heart of the merits. It's the defense. It's the credibility of the defendant's testimony. And so we do have the burden of production, but we do believe that the standard in Cameron is we just have to show that the subject matter of the communication, that it was material to the case, and that then the burden shifts to the defendant to prove that it was harmless. The burden shifts to the state to prove it was harmless.
Thank you, sir.
That's what we believe the standard is.
Mr. Waters?
Your Honor, and I'm going to walk through some of the cases in South Carolina that address this issue. But as Your Honor is aware, of course, when we deal with these issues, we have two types. We have internal misconduct, and our courts have been reluctant. Rule 606 says this as well, to delve into that unless there are concerns of fundamental fairness, like racism and things like that. And then there's external allegations of external influence and that sort of thing. And that's what we're dealing with here today. And to quote State v. Grovenstein, which is a 1999 case of the state Supreme Court, it cites Aldred and Kelly and says, we have consistently held the defendant must prove prejudice in these sorts of claims. And if we walk through all of the case law, our court has been very careful, and as much said so in Aldred, which was an internal case, to sync the analysis and the standards between those two, and have consistently held that the defendant has to show prejudice. It's their burden to do so. In Blake in 1992, the court held don't presume prejudice, and the test, of course, was whether or not the verdict was solely the product of honest deliberation or whether it was the product of outside influence. We go over to State v. Kelly. Of course, Your Honor concurred with Chief Justice Finney's dissent in that case, but in that case there was a pamphlet in the grand jury room. Clearly an external influence was alleged there. And ultimately in that case, the court held that the defendant failed to show prejudice from that particular external influence. In State v. Grovenstein, in this instance, it was clearly external. There was an alternate who was present in the jury room and even took a preliminary vote with the jurors. So clearly an external influence, far more than is even alleged in this case. That juror was removed, curative instruction was given, but ultimately the court was very clear that we have consistently held the defendant must prove prejudice, again, the burden being on the defendant. In Bryant, this was a capital case, one that I argued way back when. And in that instance, there was a police investigation, background investigation into death qualified jurors in a capital case, clearly external. The trial court conducted an inquiry with questions submitted by the parties as well, and ultimately noted that it was the defendant's burden to prove actual bias on the part of the jury. In State versus Pittman, another case that I argued before, Your Honor, in that particular case, there was a juror who had a conversation with his wife and with the bartender, and ultimately, again, the court held that the defendant failed to meet the burden of prejudice because the wife's comment was the defendant was not guilty, and the comment to the bartender took place after deliberations had begun. And then, of course, in Green in 2020, Your Honor just commented on that, and the court clearly held that the Rimmer presumption of prejudice doesn't apply here. And then, of course, went on to note that the defendant bears the burden of proving prejudice. And Cameron is a case that they rely on a lot. And I would say this about Cameron, that Cameron, of course, goes on to say that the mere fact of any official communication does not necessarily mean that the jury was prejudiced, and went on again to do a prejudice analysis and a harmless error analysis. Covington is a court of appeals case from 2000. In this particular case, there were jurors who supposedly knew the defendant and knew some external information about whether or not he had had previous difficulties with his wife and that sort of thing, clearly external information. And again, the court held that the defendant failed to show prejudice. So the case law in South Carolina, both from our state Supreme Court as well as our state court of appeals, is clear, it's in sync, it's uniform, that it's the defendant's burden to show prejudice. And that's, of course, only after there's a determination that any sort of extraneous influence occurred. And that would be the state's position, that it is the defendant's burden. And again, we can address at the appropriate time, but the state's position is as to the order of which the evidentiary hearing should go.
Thank you, sir. Mr. Griffin, you reply?
Yes, Your Honor, there is a tremendous difference in the law as to how the court analyzes juror misconduct, as in Kelly, where the juror reaches out to her pastor, gives a pamphlet, brings it into the jury room, and that was found during the course of the trial. The trial judge removed juror O, who had gotten the pamphlet, ordered every juror to ask what effect that had and if they could put that out of their mind and then deliberate. So that happened during the middle of the trial, but it was juror misconduct. All the other cases that he cited and the state relies upon are juror misconduct cases. Not unauthorized third-party communication that goes to the heart of the Sixth Amendment, right by a defendant to confront his accuser, to cross-examine witnesses who present evidence. When a third party makes an improper contact with the deliberating jury before they deliberate, that falls at the heart of the Sixth Amendment, which is a different animal altogether than where a juror engages in misconduct. And that's where you get to Cameron. That's where you get to Green, which Green says it was a procedural communication, not a marriage communication. And Your Honor, in Bryant, well, I would note, Your Honor, dissented in Kelly, but in Bryant, I mean, no jurors were interviewed, as best we could tell by the record. But in Bryant, it was a death penalty case. Law enforcement, I believe it was Horry County, were out questioning the jurors' relatives and friends and trying to get their belief as to whether they believe in the death penalty. Apparently, some of that kind of leaked back to one juror, or maybe, but there was no record saying the jurors were prejudiced by that. But the court said that behavior cannot stand, and we find prejudice based on the conduct, not on the juror's testimony. And they didn't use the word presumption, but they found prejudice. And I don't want to get caught up in this issue of do we have to establish prejudice? I think prejudice is established, but the question has to be established, but the question is it presumed under the circumstances? And if it's presumed under the circumstances, what does the state have to rebut it? And so, prejudice is a touchstone, but the question is evidentiary presumption. Here, where there's a third-party communication that goes to the merits of the case, the law is crystal clear that there is a presumption of prejudice, and the state has the burden of proving it's harmless beyond a doubt.
Thank you, sir. All right. Mr. Waters? You know, I'm not gonna go back and forth a million times, but if you want to have a short comment and additional part.
Very short, Your Honor. He said that these were not external influence cases, and every one of them that I listed was, Your Honor. Blake was a bailiff. Kelly was a pamphlet. Again, it was an external piece of information coming in. Grovenstein, it was an alternate. Again, that's an external influence. Bryant was a police investigation. Pittman was a bartender and a wife's comment. Green was a bailiff. And Covington was evidence that was not admitted at trial that the jurors were aware of. So clearly, all of those were external influence cases.
All right. I do not regard State versus Cameron as the guidance that needs to be used by me in making a determination about this case. It's a Court of Appeals case. Since that case in 1993, there have been several cases, including Green, Oliver, and others, that very specifically talk about this issue of what the burden is on a motion for a new trial on the basis for after discovered evidence that involves tampering or alleged tampering with the jury. All those cases say that prejudice must be proved, not presumed. And it may very well be that that is what's going to be shown. But for purposes of what the defendant must show as the case goes forward to an evidentiary hearing, the presumption simply by the contact, which we don't have any sworn evidence about except in the area of one juror at this time. A presumption is not the way to examine this issue, but rather specific evidence about what was said, when it was said, and how it was perceived by the juror is what I believe is required by State versus Green and other cases. And therefore, that is the approach I will take. All right, the next area of inquiry is the procedural argument of the state that this matter was untimely made. Mr. Waters?
Yes, ma'am, Your Honor. And again, we have raised the issue, as I talked about earlier, that we believe that there is at least an inquiry as to a procedural bar, that if the defense was aware of these allegations during the 10 days, then it is not after discovered evidence and the motion is untimely. And additionally, we also, as I previously expressed, have raised the issue that the affidavits on their face are insufficient to put in play an evidentiary hearing. And there are multiple cases that have in the state that have held, I think Yarborough is one of those that have held that where that showing was not made, that the trial court properly denied an evidentiary hearing. So we would just preserve those issues, understanding the court's plan or procedure that you previously expressed.
All right. Mr. Griffin or Mr. Harpootlian, let me say that I will say to the defense, to the state, I believe that issue needs further exploration, so I am not prepared to rule that this matter is untimely in the least. We're going to have a hearing on this matter, at which time this issue will be further explored. So the state has preserved its position, but you need not argue about that matter at this time.
Thank you, Your Honor.
And now the matter that to me is the heart and soul of what we're doing today is the witnesses, the exhibits, and the procedure needed with respect to the witnesses. And the witnesses, at least, are the jurors and the clerk of court, Ms. Hill. What I'd like each side to explore with me is how those witnesses should be presented, who should present them, and how they should be questioned, and whether there are any brackets or limitations that should be imposed on what these witnesses are asked. And I will begin with the jurors, which is really the heart and soul of the matter. Other witnesses are very secondary to the first issue, which is the jurors themselves. Mr. Harpootlian, you are the moving party, and you may proceed.
Your Honor, we agree, all 12 jurors should testify. I think both sides agree, Your Honor, it's a question of jurors. The only question is, not only question, but the first question would be, as Your Honor questions these jurors, would you, in all the cases the judge questions the jurors, would you want suggestions from us as to what additional questions after they respond to your questions, that raise additional questions? That's number one. Number two, each one of these jurors, except of the original 12, I think all have been interviewed, maybe two have not been interviewed by SLED and given statements, recorded statements. The rest have all given recorded statements. And then SLED prepared a memorandum of interview. We have reviewed all these videos and the MOIs, and I can tell the court that the MOIs aren't consistent in many instances with what was said on the video, to the extent that information was left out. Now, if Your Honor is going to be very restrictive and ask, did the clerk communicate something to you, and did it affect your decision? I guess that's what we're hearing, Your Honor, when you're following State versus Green. If you're going to say that, ask those questions. There's some of these jurors who indicated they heard the clerk say what the jurors that gave the affidavit for us say, and I think they're going to say it didn't affect them, which is fine. If it affected that one juror, we believe that's enough. And that juror has obviously given an affidavit to us. The alternate, which was excused, and we keep calling her the egg lady, but she was also excused, the alternate because she wasn't needed, the egg lady because the judge found that she had contact with people and discussed the case. They further indicated that the clerk said what we say she said, and we believe they should be examined. We'll be happy to do that, or the court can do that. So there are witnesses, and then we have the clerk herself. I talked to her lawyer this morning, who indicated she has not made a decision as to whether or not she would assert any constitutional right not to testify. And obviously that would be on a question by question basis. Maybe, I don't know, we're not ready to argue what the standard is on the Fifth Amendment this morning. But if she does testify, there are literally thousands of emails were furnished last week by Colleton County, some information furnished by SLED this morning and the Attorney General, which might be utilized, I can't say right now what it would or wouldn't, depending on her answer, to impeach, to contradict. So I can't tell you what exhibits there would be or what we would do because I don't know what our answers are going to be. We believe we should be able to examine her as a hostile witness. We should be able to call her as a witness because the burden is on us, as Your Honor just enunciated. Now, the only other thing I would say is this. Even if Your Honor determines that a piece of evidence or a question is not admissible for your consideration, for purposes of the appellate record, we believe we ought to be able to make a profit.
Consuming more cap.
So it may be that Your Honor allows us to go forward, and then in your decision decide
This
it's
space
not
is sounds
relevant,
and
in your
coughing
decision
and stuff.
decide you didn't consider it or whatever. But stop and go is going to elongate that hearing dramatically. And again, since you're the finder of fact, fact. You can decide not what a jury's gonna hear, but what it matters to you. So, we think that the examination of the court should be wide open. And we think that the, exhibits we would use to impeach her, we would attempt to keep it relevant to the specific issues in this case. I mean, her son has been indicted, for instance, her son's been indicted for wiretapping. There seems to be some inference, at least what we read in the papers, we don't have any specific knowledge, that she was aware of that, and that wiretapping was in relation to some ethics complaint about her. That's not relevant. We're not gonna ask her about it. Now, we're continuing to examine whether or not there is some connection there, and we're investigating that. But at this point, I would tell you that's not where we're going. Where we are going, by way of example, is we have been furnished an email that she got on February 24th from somebody, which was a photo, a screenshot of a looks like a posting on some sort of Facebook page, where the ex-husband of a juror, not the egg lady, alleges that his ex-wife has been talking about the case, and she is going to vote guilty because she hates men. Now, we know she got it. We know she got it on February 24th. Yet on the morning of February 27th, she tells in the chambers, the hearing we were all present at, that she had seen a Facebook page posting by Egway's ex-husband, alleging that she was talking about the case, and she didn't think he was guilty. That Facebook page had never been produced, and then she produced a Facebook posting, she said, by the Egway's husband. Turns out to be a guy I interviewed in Georgia, apologizing for what he had posted on Friday night, which concerned his wife's aunt meddling in their marriage. I think that's fertile ground for cross-examination. Your Honor may disagree with me, but I still would like to put those items into evidence for the appellate record at the time. But the last thing I would say is this. In terms of Your Honor questioning the jurors, we need instructions from you as to whether you want, after you finish with the juror, do you want us to submit questions to you? I doubt you're going to let us question them. How is that process going to work? And will that be done someplace? Will it be done in this courtroom? Will it be done somewhere else? And if the juror is going to be questioned outside of this courtroom, will there be a way for the public to hear what they have to say? Thank you for your indulgence.
I'm still here, guys.
Mr. Griffin rightly points out, it's not just what they heard, may have heard from the clerk, but is any of the other jurors, for instance, Egway, we could be calling her, gave an affidavit indicating Becky said things like, don't be fooled, watch the body language, watch body language testifies, Mr. Murdaugh. Did she relay that to any other jurors? It's not just or did the sitting juror or the alternate in the
I guess my live stream's not that interesting.
one other point, in the memorandum of interview, now, the Clerk's private lawyer, Mr. Lewis, objected to any videotaping or audio taping of the Clerk when she was interviewed. But in the memorandum of interview, that is, the Clerk indicated she had conversations with the four lady outside the presence of the rest of the jury about what was going on in the jury room. Obviously, I would cross-examine her on that, but it may be necessary if she testifies to things that are inconsistent in that MOI, for us to call the SLED agent that did the interview to corroborate the MOI. The MOI may be introducible in and of itself as an exception to the hearsay rule, but I believe it may be necessary for us to call the SLED agent. We're not going to, and Your Honor, you've indicated that you're not going to want any sort of summaries of those interviews by the jurors when we talk back in chambers, or necessarily the MOIs. You want your own fact finding with the jurors. To the extent that they contradict those, we may put all of that into the record for appellate purposes. And if you want to see those before you have this hearing, we could obviously put those. We could put those in the record today, or have those available to you, both the MOIs and the videos. We're obviously we're going to do whatever you tell us to do, but we're looking for some guides just to, if there's anything we can get you prior to that evidentiary hearing concerning those memorandum interview by the SLED agents and the videotapes. Whatever you instruct us to do, take the course of development.
Whoever joined us, thank you.
Your Honor, you mentioned, and Mr. Griffin reiterated to me just now, and obviously you don't need to tell us this today because we're not going to be doing the questioning, but there is the consideration of 606B and the incursion into deliberations. At some point, we don't need to know that today, but at some point prior to you questioning the jurors, we'd like you to enunciate what your position is on that.
You're going to have to outline that a little bit more for me. What part of 606B are you discussing?
Well, it says, if I can find my glasses. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind as or emotions as influence a juror to assent to or dissent from the verdict.
All right, and what are you saying that imports for this?
Well, I mean, for instance, if we prove to you that the court said, do not be fooled, or, watch Murdaugh's testimony, watch the body language inferring he was lying, he would be lying. One of the issues is if the juror who sat during the deliberations who said that the court said that, did she discuss that with any other jurors? Did she infect the jury? Does this allow you to do that?
Well, you certainly, if you go to 606B, it gives you some guidance about that. It says, an inquiry into the validity of a verdict or indictment, a juror may not testify as to
If anybody thinks,
any
what is this gonna
statement
happen?
during the course of the jury's deliberations, or to the effect of anything upon that or any other juror's mind or emotions, influencing the
Cases
juror
go down,
to
I don't
assent
think I'm
or
gonna have time to
dissent
do
from the verdict or indictment, or concerning the juror's mental processes, except a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention, or whether any outside influence was improperly brought to bear upon any juror, nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which juror would be precluded from testifying be received for these purposes. I take that to give us the guidance we need about the parameters of the questions.
But if, again, if the juror that gave us the affidavit, would she be asked, did you discuss that during deliberations? Could she do that?
That apparently is very questionable under the terms of 606.
Yes, ma'am.
And I intend to abide by that. The way those questions have been asked in many cases I have reviewed is to ask the juror whether that's still their verdict. If they ask about improper context and they talk about improper context, then the way to pursue it beyond that for the judge is to ask about the impact on the verdict, not on the deliberations themselves. That may be a small slice of difference, but I think it's very important to understand that no one, not myself or anyone else, is going to be asking the juror about the specifics of their deliberation, and the rule is quite clear about that.
Okay. And is it clear that you will not be using the SLED interviews or MOIs to attempt to impeach?
I told you when that was brought to my attention in our Chamber's conference this morning, I haven't made my mind up about that. I don't know what's in those summaries or anything else, and we're going to have to discuss that. But again, I'm the one doing the questioning at this point, Mr. Harper.
Yes. Yes.
And I'm trying to pursue what you all are asking, and I'm going to go to the state now and see what their reaction is to what you said.
Thank you, Your Honor.
Mr. Waters?
Thank you, Your Honor. May it please the court. Your Honor, again, we would concur with what Your Honor just said about Rule 606 and, of course, all the cases that we've talked about, and the need to show prejudice. And obviously, when you're talking about external influence, that prejudice, which will be an appropriate subject of inquiry to the jurors, is whether or not there was an impact on the verdict. And we, of course, have suggested to Your Honor, not only based on the cases, that should be judicially conducted in a manner that protects the privacy of those jurors and that protects the privacy of their identities. These jurors were drafted into service, and this inquiry, of course, has to happen, but it needs to be conducted in a manner that respects their privacy and should be, of course, judicially conducted. We have suggested those two questions. If we look at the Bryant case specifically talked about the fact that depending on how the examination goes, there could be questions suggested by the parties. And obviously, I think we would need to cross that bridge if and when that bridge needs to be crossed. And that starts with the court's inquiry to those jurors, and only if something arises that needs further inquiry could that be addressed at that point. And that could be even a discussion from counsel with the court as to what additional questions may be proper. When the state first became aware of these allegations, the first thing that we did was have SLED do an independent investigation, and the goal was, good, bad, or ugly, to get to the bottom of what, if anything, happened. And the result of that is why we're still here today. And that is that in speaking with the jurors that spoke to us, that the balance of the evidence, as well as in talking to the clerk staff, was that there was no impact on any verdict. There was nothing unprofessional or untoward that happened that had any effect on the verdict. And so when we did that inquiry, and that is what the jurors said, that is why we're here today, and that's what this hearing is going to address. The only juror that we have is the one who filed the affidavit. That's 630, and even she, or that person, only said that she, eventually voted guilty because she felt pressured by the other jurors. Did not even mention any external impact. And so unless she's going to change her story, that is what was in her affidavit. So the balance of the evidence is the reason why we're here today, and why this hearing needs to take place. Your Honor, as far as inquiry to those jurors, again, there could be a need that the parties would suggest questions, and it could be, depending on how things go, that the affidavits or maybe even the recordings, all of which have been provided to the defense, the full recordings of those interviews of any potential witness in this case have been provided to the defense. It could be that issues could arise from either the state or the defense as to impeachment, and we can address those issues as they arise under the appropriate rules, 608, 613, and the like, dealing with not only prior inconsistent statements, but other evidence that would be properly impeachable. Ultimately, I do need to address one thing as it deals with all of this, and that is the defense's contention that somehow the clerk is a party opponent in this particular case, and we believe that that is incorrect. Obviously, there is a hearsay exception or a non-hearsay determination in the evidentiary rules, I believe in 801, that excludes statements of a party opponent. But just because the clerk is an elected official and of the state, that does not make them a party opponent in the way that term is defined. A party opponent is an active litigant before the case, and that is, I think, different. So we would certainly say that the hearsay rules would still be in effect as it relates to Ms. Hill and any testimony that she may provide. I know there's been some discussion about the order in which the witnesses may be called and whether or not Ms. Hill would be a hostile witness. And obviously that's under Rule 611 and I believe C, which will allow leading questions, if a person is hostile. I think, again, at this point, I don't know that any showing necessarily has been made, but I understand the defense may raise that point and we may have some arguments at that time. But I don't know that there's been such an identification between Ms. Hill and the state that would allow her to be identified as a party. I think that's far out of bounds.
I have a feeling she's going to be prosecuted.
Applicable to allow defense leading questions
The
under
lady.
611C. Your Honor, in looking at the type of examination that would need to happen here, and again, the issue also arose of the Fifth Amendment. And I know that the defense would like to brief that issue, and we're happy to respond. We don't know exactly how that might arise in the course of any examination. We need to cross that bridge again when we get there. We would say, though, that the Fifth Amendment is question specific. And so, again, it may be something that this court has to rule, as is in any sort of evidentiary presentation, question by question, based on any objection by the parties. So it's kind of hard to say that exactly what a blanket position would be until we actually get to that determination. Ultimately, the defense referred to some information provided this morning. Actually, both sides exchanged last night their communications with the clerk during the course of the trial. So both sides did that last night. And there were a lot of communications with the defense as well. And so, again, I just want to point that out that there's any sort of allegation or insinuation that the state's not providing information. We've been very diligent about providing any and all information to the defense. And if any additional information arises, we will continue to do so. But both sides exchanged that last night. And of course, there's been some reference in their filings as to emails that were forwarded from the clerk to me and to my paralegal. And they've actually even listed me on the witness list. And Your Honor, as we have had a chance to peruse the defense communications with the clerk, there was just as much communication and offers of help. It was just a uniform across the board courteousness that's reflected from those. So we think that that's a non-issue. And we think that should not be something that arises during the course of this evidentiary hearing, at least as it would require communication from or testimony from attorneys. Your Honor, ultimately, as we look at the inquiry that will need to be conducted, as the state has made clear, it starts with the jurors. And only if something arises in that inquiry, further inquiry to those jurors may be necessary. And that could be in discussion with the parties, as I've stated before. And then I know Your Honor has indicated the clerk should testify, and we certainly understand that. The clerk filed an affidavit denying any of these allegations. And so, again, as we address the clerk's testimony, the state would have objection to some of the information I believe the defense would propose to examine her on. We believe that an inquiry should be limited to what is appropriate and relevant impeachment, but not should be just a far-ranging fishing expedition or full inquiry into a lot of subjects that have come up since the trial that we believe are not relevant to any inquiry that is before the court here now. Obviously, rules 404, 401, 402, and 403, as well as, which of course address relevance and 403 objections, 404, which addresses other crimes or wrongs or acts, Rule 606, or excuse me, 608,
Is that you, Sean B?
addresses
Still?
inquiry into other specific acts and impeachment, and Rule 613, which talks about prior inconsistent statements. All of those rules potentially could come into play depending on the nature of the testimony and the nature of the inquiry. But there have been allegations since the trial about the book about this wiretapping case, about investigations into alleged use of office for improper gain.
I know.
Again, all those are subsequent to the trial.
I think he's not gonna walk
Goes,
free, but
the state would raise appropriate objections at that time to limit the.
he's gonna get a new trial, I think.
What is before the court, we would
When you get
expect.
acquitted, I don't know. Unless he got new evidence saying he didn't do it.
Make those
I don't
particular
know.
evidentiary objections as things developed. Ultimately, that would be the state's position.
I don't know.
I know that we're trying to.
It would have been.
put
I
as
think it
much
would have been
weight on
home free
most
if the
as we
lady
can
didn't
at
ask
this
question.
particular time.
My opinion.
But I think the reality is that the court's inquiry to the jurors
Would've gotten
will really
Another
determine.
trial, and it probably would have been a couple of home free.
From there, and at that point, the state would, take the positions that I've outlined here today.
You reply.
Please, court, Your Honor. 404, I find it somewhat ironic. The state is quoting Rule 404, Your Honor. One of the exceptions to 404, I know this would be surprising to Mr. Waters, is motive. As if he's never heard that before. He told me this morning one of the assistants that worked for Ms. Hill during this trial was told by Ms. Hill during the trial that a guilty verdict would be good for sales of the book. Motive, selling books. So we believe we should be able to get into that. We should be able to ask Ms. Hill about it. If she denied it, to call that witness, that assistant, and have her testify that she was told that. I mean, why would a clerk do what we allege she did? We think is important for Your Honor in terms of credibility and context. That's number one. Number two, Your Honor, I think we've all agreed, you're going to ask the questions, whether we agree or not. And we do agree with that. The question is going to become, as we go through that process, how, if a juror says X and they've said in their interview Y, or if they've said to us Y, or didn't include it in their original affidavit, and you don't ask that question initially, how are you going to handle, or do you care, how we suggest to you a further question? Because as Your Honor's seen this morning, the back and forth can go on for a while, and we certainly don't want that to go on with a juror. So we're going to need some guidance on that. I'm not expecting that guidance this morning. But the last thing is, as jurors are examining, I need to understand a little bit about the logistics. Are we going to do it in this courtroom? Are we going to do it in another courtroom? Is the public going to be able to hear the responses? Will there be an audio feed if we do it somewhere else? Are you going to have cameras turned? You can do it in this courtroom, have cameras turned off? And we're obviously not going to refer to jurors by their names. Even though 3 of these jurors went on the Today Show, another one went on ABC. They were all in the courtroom when the judge had them brought in. They were in the courtroom, all except one of them, for the verdict. Cameras were there then. Again, I'm sensitive to their anonymity, but I don't know that any of them have any real anonymity anymore. Saying that, I think it's important not only for Your Honor to hear their answers, but for the public to hear their answers. Thank you.
All right. With respect to the jurors first as witnesses, I will be doing the questioning of the jurors, and I will notify the parties pretty promptly what I intend to ask the jurors. The ambit of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I understand that you, on the defense side, have views about what further should be asked of jurors on two levels. One, as a predicate to what you want to do with the clerk herself in examining her. And two, as a means of further attacking the credibility of the clerk in her testimony. I have not seen any of the SLED material or memoranda concerning the state's summary of these interviews and so forth. I will be open to receiving that if it's done promptly, because we've got a hearing coming up the 29th, and I want there to be plenty of time to revise any current ideas about who to subpoena, who to call as witnesses, and who has to do that. But I can tell you that I am very, very reluctant to turn this hearing about juror contact into a wholesale exploration of every piece of conduct by the clerk alleged to have been improper on its own, indicative of her or characteristics of personality or anything of that nature. This is a very focused inquiry that deals with this jury and what impact contact, if any, had on this jury. So I am very mindful
Who joined us?
of the nature of it. As I
Whoever
say,
joined us,
I'm
thank
not
you.
excluding
I appreciate it. Tell me who you are.
submission in advance of information that would take the questions beyond the limited questions.
No, I see only Sean B here for now.
But I will be very hesitant about any of those
I'll
questions.
mute myself because I'm gonna be eating.
Those questions.
I don't want you to hear me chewing.
As it involves questions to Ms. Hill similarly. This is not a time to explore every mistake or incorrect statement or false statement that ever has been made by this witness. I am the judge of the credibility of this witness for purposes of this new trial motion. I don't think it's necessary, nor do I think it's proper, to explore each and every impropriety alleged to have been committed by the clerk. At the same time, what specifically should be asked is something that I will look at as I look at the submissions that are made before the hearing takes place about what is requested to be allowed as topics for questioning of the clerk and what exhibits should be used. I can't imagine allowing thousands of emails to be made exhibits in this process. Either emails sent by her to attorneys in the case, to other court officials in the case, or to other individuals during the course of the trial of the case. I certainly will try to preserve the appellate posture of defense in this regard, but I will put certain limitations on just a wholesale exploration of every problematic piece of conduct, ethical dealings with the county, and so forth. This is a very focused inquiry about this jury and its ability to render the verdict it rendered in an impartial manner. So I say that to tell you that when the clerk is offered, and I think the clerk is going to have to be offered as a witness, the whole allegation revolves around the contention that the clerk made contact with the jury about matters material to their verdict, that contact was improper, and that it impacted their verdict. There's a whole lot more that Mr. Harpootlian has indicated he'd like to explore that I regard as totally extraneous to the inquiry that we maintain. I'm not going to allow those questions to be asked by way of proffer and then have the clerk answer those questions and have that be the proffer, although I consider them irrelevant questions. We're not going to handle the case in that way. If I exclude a certain question from being asked, then the proffer will be whatever in writing is chosen to be offered in that regard. But I will not conduct a hearing where there's a whole side hearing in which every question desired is asked and either required to be answered or dealt with in some other way. I don't think that is an appropriate use of this very targeted hearing that I'm directed to have. I also think it makes a great deal of difference whether the questions that are being asked relate to the clerk's conduct at the time this case was tried, as opposed to other conduct at a later time or in connections with other things than the trial of this case. So I will be looking very carefully before we conduct this hearing and trying to give the parties as much advice as I can about what I would find to be acceptable topics to pursue. I think you're entitled to that, but I also think the record of the case is not to be used as a platform to explore each and every fault of each and every witness, whether it be the juror or the clerk. And I'm not going to have the hearing conducted in that manner. I think there are other ways of preserving topics that I rule should not be pursued than having those questions asked and answered, even though I ruled that they are not proper in the hearing. So I hope that explains kind of where I am on the subject of how questions are asked. And therefore, some of the suggestions that are made in the filings you've made with me about the additional witnesses you'd like to call and subpoenas, I think we need to be sure we're all on the same page about what is acceptable in evidence and what is not. But I can tell you that I would not allow the subpoenaing and examination of attorneys in this case, of the judge who heard the case, or any of those type of witnesses. This case is very focused on the jurors and the clerk of court, as I see it. Now, it's about 11:15, not close to it. I'm going to do this. I'm going to take a break for a minute. Let's take until 11:25 as a break. And in that time, I would hope that you formulate the other things you think we need to look at by way of the specifics of how this matter is to be conducted. I will then do two things. When I come back and ask you for further ideas, both sides, as to who should be called, get very specific about who can be called and who cannot, who should offer these witnesses. And I would also at that time ask those who represent potential witnesses in this matter to come forward and have a conversation with me about your position on behalf of your clients. I think that's particularly important because as we have the actual hearing itself, I've never heard of a situation where a witness can have their lawyer actively participate in the examination of the witness in a proceeding in which the witness is being offered. So I would not allow that, but I think we can protect the legal positions that attorneys for witnesses want to take and need to take and want to put on the record by pursuing in the way I just outlined, and I'll be prepared to do that when we return. All right, court will be in recess.
Thank you, Your Honor.
Thank you, Your Honor.
With regard to the subpoenaing of witnesses, the parties should subpoena these witnesses, and when it comes to the jurors, I would urge that the parties, the state and defendant, jointly deal with the issue of subpoena of these witnesses. I do not think it is the court's place to subpoena witnesses or order witnesses' appearances. This case is driven by the parties and their positions. The initial position of defense was that only certain jurors should be called. The state said no jurors should be called, but if you do, all should be called. All who sat on the case should be called. If the parties can't agree on how that subpoena should be accomplished, then I'm sure they'll let me know, and I'll try to take some measures in that regard. The concept I would have is that the jurors would report to a place that I will specify, and when they report, they would be taken to a room with appropriate supervision by court personnel, and then called individually to recite their testimony. And then when their testimony was complete, they would simply take their place in the jury box until all were questioned. And then if there were any questions further by me that would be collectively made to the jury, I could do that. And if there are any further questions that were submitted to me by the parties that I chose to question, I would do that. And then when all of that was complete, the jurors would be allowed to be dismissed. So that is how I would handle the juror witness portion of this. And of course, I know I'm going to get some commentary from each side about that. That's why I talk about this in advance. The other witness that surely needs to be called because of the allegations made is the clerk of court. The state has submitted a preliminary affidavit by the clerk of court, and the defense has many areas that they want to explore for the court. Again, I would like for the parties to develop some joint way of subpoenaing the clerk of court. And if I need to be a part of that, then I'm sure the parties will let me know. But I say this for the benefit, particularly of the attorney for the clerk of court, to know that I would expect that the clerk of court will be called as a witness in these proceedings, 29, 30, and 31 if necessary. We'll be using the same courtroom for these proceedings, this courtroom. And 3B will be used as an overflow for the press. Excuse me, 3A is the one over here, and that's the one I'll be using to conduct the hearing. This courtroom we're sitting in now will be an overflow courtroom for press with I'm sure, a court TV monitor that's available for them to monitor the proceedings if there's not enough room based on the attendance. Today, it might be plenty of room. We'll see. We'll have this I will try to figure out a way to be sure that the broadcast in here of the proceedings will not interfere with the conduct of the hearing past this partition next door. I will trust Mr. Vendor to work with the press to arrange the courtroom and the overflow room in accordance with the rules I will set forth here and anything else that may come up that needs my attention. I think that covers it at the present time. So the first thing I'd like to do is to get some clarity from the attorneys as to what furthermore, for the parties, as to what furthermore needs to be discussed. And then after that, we'll explore the attorneys for the jurors and the attorney for Clerk Hill, any other issues that still need to be developed. Mr. Hopkins.
Please support, Your Honor. I'm trying to make sure I understand what you just ruled. Are you ruling that we cannot call the alternate juror or the so-called egg lady to corroborate what was said to the sitting juror, since they were all told this at the same time?
I'm not sure I understand your question, but I'm telling you that these jurors, these alternates would be called apparently to testify as to what the clerk said.
Yes.
At the present time, I see no necessity for them to be called to say what the clerk said, because we're talking about what the clerk said to the remaining jurors, those who actually sat on the case. The corroboration is something I don't think I need at this time. I think I'm perfectly capable of evaluating what the jurors tell me, and I'll do that. I think I'm also perfectly capable of evaluating the credibility of Ms. Hill and the jurors for that matter.
Well, Your Honor, for us to, and then you said you wouldn't allow a proffer of that except in writing. Now,
yes, I'm not going to have a courtroom proffer of any kind. If you want to proffer what would be offered by means of affidavits, copies of emails, anything else you want to, that's fine. But I am not going to have a courtroom proffer, no. I think the only reason for the proffer would be to preserve your right to appeal. I believe your right to appeal my rulings will be perfectly preserved, frankly, even if you didn't have a proffer, but even more so if you supply an in-writing proffer.
Well, I'm trying to determine whether an affidavit is sufficient for an appellate court, federal or state, when the state won't have an opportunity to examine that witness. But I mean, they've given, I mean, we can get more detailed affidavits. You know, these people are witnesses to what the clerk said to the juror who deliberated. I don't understand how that can't be relevant to Your Honor's decision. I understand there's two steps. One, did she make the statement? And two, was it prejudicial? These witnesses corroborate she made the statement.
Well, of course, that's what you say. So far, I haven't seen any of that. If that's what you say and you offer it to me in some form that I can evaluate it, I may revisit that decision. At the present time,
Okay.
but at the present time, I see nothing that prompts me to think I need to have people who did not sit on the case talk about what they think the clerk said to other people, when I've got to direct people to who it said that I will question.
Well, Your Honor, we did submit an affidavit, but I have no problem with going back.
You submitted one alternate affidavit
Right.
and one affidavit of a dismissed alternate. I'm aware of that.
Right. So.
And that doesn't prompt me to change what I just said to you.
All right, we can get you more specific. I understand what the questions are you have, and I would only put those folks up to deal with those very limited issues that you described. Put them up in 10 minutes.
Well, again, I'm not going to rule in a vacuum. I'll see what you say, and I'll rule upon it.
We'll get affidavits and file them with the court.
Very good.
Thank you.
Your Honor, just one issue as to logistics. Obviously, these jurors are down in Colleton County, and we're up here in Richland County. I've spoken with SLED, and in as much as we need, there may be jurors who need transport. SLED has certainly agreed to have 12 cars if we need to make sure that they're individual. They can then come in through the garage, and obviously they'd be brought up to a jury room. I think Your Honor indicated they can be in a jury room with a bailiff in there to make sure that no one's talking about their testimony and that sort of thing, but also so that they don't have to come in through the public entrance and that sort of thing. So that would be.
I think that would be a good solution, and of course, to satisfy the concerns that the defense may have, you could either have a member of the defense team or one of their employees ride with them, or if you could agree upon a sworn statement by the agent or person that does drive them, that they, A, will not say anything, and B, did not say anything, then that may cure the problem too. I think you all can work that out. But I do think having proper transport would, first of all, be a comfort to the witnesses themselves, the jurors themselves. But if they can arrange something otherwise, of course, they'd be free to do that. But to the extent it's a burden on them, yes, I think that's a good idea. And in all events, I would want arrangements to be made to have the jurors come to the parking garage in this building and be escorted up in a private way into their assembly room.
And yeah, absolutely, Your Honor, and we will, and I'm sure SLED, I've already spoken to them about that, have uninvolved agents who will be under strict instructions not to discuss the case, and happy to have them sign affidavits or whatever. To that
Very good. All right, anything further before I go to the lawyers for the jurors? All right.
Your Honor, only one other point, and that is you asked us to give you exhibits that we would use.
Yes, sir.
Having not asked or had the opportunity to ask Ms. Hill a single question, I can't tell you, in terms of, there's not thousands of emails we've used, probably 5.
I'm just going on some of the descriptions that were in the filings y'all have made to me.
Well, we've received thousands of emails from Colleton County based on a subpoena we issued. We've received hundreds of pages from the AG's office and from SLED. We are.
It'll make it a lot simpler if it's a small number and a discrete number by submitting them to me. Again, I told you I would evaluate that when I get them.
Of course, I don't think you can evaluate them until she testifies. You know,
I think you're gonna have to trust that I am gonna do some evaluating before she testifies.
Okay, and Your Honor, you know, she's given an affidavit denying making any of these statements.
She has.
So these alternate jurors that have been dismissed, would you allow us to call them to impeach her if that's what she testifies to?
At the present time, the answer to that is no, as I have indicated. But again, I'm not gonna rule in the vacuum. I would hope that what you all do is send me a pretty specific idea of what you want and how you want me to permit it. So I'm not gonna rule on something I haven't seen yet, which is your proposal as to exactly how these witnesses and alternates can be used.
All right, we'll get more extensive affidavits from those two alternates.
Oh, okay.
That's
fine, or descriptors of some sort from you as to what you intend to do. I'm not gonna dictate how you do it, but I'm gonna have a lot more than just kind of the generalities that have been discussed in these briefs in order to permit.
Well, I think we're gonna need an affidavit for appellate purposes, nothing else. I mean, my description to you is not evidence.
Oh, I agree, but you know, again, I will tell you how I'm gonna accept the proffer. What you put in the proffer, in the written proffer, is up to you. I don't want to dictate that or manage it.
Well, I just want to say that we're going to hopefully be able to get affidavits from these folks.
Yes.
Much more descriptive than the original affidavits.
All right.
Thank you.
All right.
Your Honor, may I consult with counsel very briefly?
Certainly.
One of the things that was discussed earlier was the independent SLED investigation that was done. There were recordings of some of these interviews and MOIs prepared that were just meant to be summaries. I know Your Honor mentioned earlier that you would be open to receiving those.
Sure, I'd be glad to review any of that.
Discussed that with counsel, and I believe they said, well, we want to send the ones we want to send. I think if Your Honor's amenable to that, we would just add Your Honor to the discovery upload that was provided to the defense so that information is available to the court for whatever purposes the court deems necessary.
Can I ask this?
Yes, ma'am.
First, would that discovery upload include your interviews, the tape of the interviews, as well as your summary of them?
Yes, ma'am.
All right. I will ask you to let my clerk, Eva Diaz, talk with you afterwards about how to send me something of that volume.
Sure.
Our court, IT has a lot of barriers in our system to us receiving even conventional websites and web tools for examining in volume documents. And so I will want her to interact with you all about exactly how I am to receive that material. But yes, I would be happy to receive it.
And we would be happy to get a couple of flash drives and provide it that way, if that makes sense.
That might be the better way to do it, because again, I can very easily examine a flash drive, even though it takes a long time, particularly if you're kind enough to provide an index at the front of the flash drive as to where the various materials are located. That might be better than using one of these web document sources, since so many of them are excluded from our system.
All right. Well, we'll prepare one and have a copy for you, Your Honor, and then for Ms. Diaz, the clerk, as well. Thank you.
Now, on my list, I have in the courtroom at this time, Mr. Bland, who represents certain of the jurors, Mr. McCullough, who represents certain of the jurors, and Mr. Lewis, who represents Ms. Hill. Are there others in the courtroom who represent jurors or Ms. Hill?
But Your Honor, Ronnie Richter, American Plains partner.
Went a little fast for me.
Ronnie Richter,
Oh,
Mr. Plains partner.
right. Any others? All right. Well, then we'll begin with you, Mr. Bland, if you and Mr. Richter would come forward.
May it please the court, Your Honor. Ronnie and I represent 4 jurors who rendered verdicts in this case.
I would like their numbers, but only if that doesn't violate the attorney-client privilege. You may give them to me now or later.
Can I give them to you later? I have them now. Our job is we want to preserve their anonymity.
I understand.
2, we want to make sure that they're not harassed. And 3, we want to make sure that the verdicts of their conscience remain. And that is not only because they voted guilty. If they voted not guilty, we would feel the same way. After hearing what Your Honor has established by the way of procedures, we're very comfortable with what you have established to protect their anonymity and that they're not harassed. Ronnie came up with a good suggestion. Maybe you renumber the jurors 1 through 12. And that way, because there has been some public disclosure of the jurors' numbers in some of those emails, they were the big batch of emails that Mr. Harpoon referenced. So maybe we cross-reference with the chart 1 through 12 and the juror numbers. But as far as the questioning goes, there's no need for us to be part of this. You're going to make the questions. You indicated that you're going to preserve their anonymity, that they can't be photographed, they can't be on videotape, and that's about all we have to add.
Yeah, Your Honor, I would amplify that I certainly respect and appreciate the significance of the issues that are before you. And I respect your decision that you're going to make this public. I would have asked you to make the jury portion a closed courtroom. And Your Honor, only for this reason, that I don't know what the jurors are going to say, I don't know what you're going to rule, but let's just say in a hypothetical setting that because juror number 9 said something that you believe deprived Mr. Murdaugh of his right to a fair trial, you're going to grant a fair trial, a new trial. I would hate for there to be any mechanism for somebody to backtrace to who was juror number 9. Because I know the public has very firm opinions about this matter, and I wouldn't want that person to be subject to any kind of public scrutiny. So I would have asked of you that for the juror portion that we do closed courtroom, that the press would be present, that their likeness, both voice and face, be muddled, just as an additional safeguard. But I certainly appreciate what the safeguards you have put in place. I respect your rulings. I just throw that out for consideration. And on a broader perspective, I know that you've had this experience as well, Your Honor. It's becoming more and more difficult in this state to see the jury. And I can't think of anything more injurious to jury service on a broader perspective than to see, jurors who've given up 6 weeks of their lives being pulled back in for a process like this, as necessary as it is. So I worry that the process be handled as gingerly as possible, so as not to further prejudice our ability to get juries going forward.
Thank you, sir. What I will do is this. I think your suggestion of renumbering is a good one. It's something that my clerk and I have talked about between the two of us as well. In every proceeding I've ever seen where a juror was questioned, in every case I've read where jurors were questioned because of allegations either during trial or post-trial that they had been tampered with, those proceedings have been in open court. And I don't feel it would be appropriate for me to have some kind of in-camera proceeding, even if it included the attorneys that would have to, and even if it included members of the press but not the general public. I don't think that is in keeping with the public nature of trials in this state and public nature of court proceedings. However, I think we could make some protective arrangements for when they testify and their ability to be dismissed after they testify that would protect them from being set upon to the best extent possible. So that is the way I will handle it, and I hope all things on balance that is as protected as you think it needs to be.
We trust you, Your Honor. Thank you.
All right.
Your Honor, on behalf of our clients, we will accept their service of the subpoena so that they don't have to be
Well,
served.
that's great, and of course, you don't represent all of them.
No, our four.
You're for, but that's great, and it may very well be that these parties are going to be able to work out something with respect to some of the rest of them. I don't know, but I appreciate that on behalf of the ones you represent.
Do you want me to come up and tell you our juror numbers, or you want me to wait?
No, sir. You can. I don't need that at this moment.
Okay. Thank you.
Thank you, Judge.
Yes, sir. Mr. McCullough?
Honor, would you like me here or later?
Oh, go to the podium if you would, please.
I believe by some of your rulings today, they've satisfied several of the things I was going to mention. One, Your Honor, was, of course,
How many jurors do you represent?
I'm sorry, Your Honor, I represent number 785 and 630. One is was a deliberating juror, I suppose we could call her, and the other was the removed juror.
Right. Now, with respect to the replaced juror, I think my ruling about the end of any testimony from that juror satisfies any requirements you made. I rule that I will not hear testimony from that juror, alternate juror at the present time. Now, Mr. Harpootman is going to submit additional information. As regards your client, I ask you to submit that information to you as well. And then I'll see if there's any revision of the position I take about that. You also represent one sitting juror, so you may continue.
Your Honor, the other juror was not an alternate. She was an actual seated juror.
That's right, the sitting juror.
Who was removed at the end of the trial.
Oh,
Prior to deliberation. Whoops.
I need Mr. McCullough to speak up, please.
you need to speak up some, Mr. McCullough.
I don't get that much, Your Honor.
Yes, sir.
Your Honor, if you'll indulge me just a moment, I think much of what you've said today bears on a quote that I'm taking from the response of the state, which was filed and was part of your record. And my letter of November 10th responding to that filing is also part of the record. But the state said that jury duty is this cornerstone civic duty, needless exposure to the jurors to litigative stress and impeachment by zealous attorneys in a case, especially of this public exposure, can only serve
Happy
to
Tuesday, everyone.
discourage citizens from willingly participating in this civic duty. Your Honor, I'm delighted with your ruling that you'll be asking questions. I've been subject to your interrogative skills in my appearances before the Supreme Court. So I'm pleased with that, and I check that off the list. I would like, Your Honor, for you to take judicial notice that there have been excessive public comments by, and I have to say, Your Honor, in my letter of November 10th, I took Mr. Waters, who signed the letter, to task for labeling one of my clients, one of these jurors, as dishonest. I think I wasn't pleased with that. I think that discourages civic participation. I would ask the court to admonish the litigants, attorneys.
Mr. McCullough, let me stop you there. I am not aware of any of what you're talking about in terms of comments about jurors or otherwise. So that's just not something I'm going to take into account by listening to it or by taking any judicial notice of it. I don't know what I would be taking judicial notice of. I do not know anything about what you're talking about.
Well, Your Honor, both my letter and the response of the state are part of the record, which you obviously have not gotten to, but I would assume yet. My only request is either admonish lawyers, officers of the court in this courtroom and outside of this courtroom who represent people to be cautioned that this is a search for the truth, not an effort to protect a verdict, nor an effort to discourage people from participation. And negative commentary does that, or runs the risk of doing that. That's all I'm saying.
I understand, and I decline to instruct or admonish participants in this procedure in any way about what you say.
Thank you. Your Honor, next, I like Mr. Richter and Mr. Bland, appreciate your efforts. I suspect that we will decline a ride to the courthouse, but I would ask the court to consider allowing the jurors who choose not to ride with SLED agents be permitted an entry and exit from the courthouse that would involve or relieve them of the necessity of coming through the front door.
I think I've already said that I will make arrangements for juror witnesses to report to the basement where the law enforcement station is, and they'll be appropriately directed to the assembly room.
And Your Honor, lastly, I think, if I understand your rulings or discussions about the process that will occur here, this may run at odds with it, and I'm not arguing with you, Your Honor, you know best. I am of the belief that this litigative stress that I earlier referenced could be avoided, and the public and media not denied their opportunity to gain access and knowledge of the proceedings by not exposing these jurors to a crowded gallery, a full gallery of press, by allowing its recording through, I understand, court TV will be the pull camera. That is to say that I have actually, in my history, participated in proceedings that involved the questioning of jurors, which was done in camera. So I don't think it's without any precedent, but I would obviously respect your ruling, but I would ask you to consider or reconsider that no damage would be done to the right of the public to know and participate in the proceedings, but you can accomplish the same thing by allowing the pool camera and avoid the distraction and the imposition of that on these jurors. And
I hear what you're saying, and I'm not inclined to change the ruling I've made at the present time, but I'll keep an open mind about it as we make pre-trial preparations for the hearing. At the present time, the jurors will be examined in the courtroom, as I have indicated, with appropriate identity protection.
thank you, Your Honor. And subject to your rulings, I will have both of my clients available for these parties as they might be needed, subject to your subsequent rulings.
Thank you.
Thank you.
Your Honor, do you expect all jurors to be present for all 3 days?
No. Let me make it very clear that I expect the jurors will be the first witnesses to be called in these proceedings. And the jurors will testify, and then they would be dismissed. They would not be required to stay for the rest of the proceedings at all. So that is very much a part of my thought about what it takes to protect their identities. They would be protected as best I can, and the ability of others to come and beset them with questions as they leave would be protected. So,
Do you expect that you could get through all 12 in one day, or should I tell them, because a couple have to take off for work?
yes, I do.
Okay, thank you.
All right. And Mr. Lewis.
Your Honor, I'll be brief. In light of your rulings, I don't think you need much from me. The only thing that I'll add is I'll have Ms. Hill available for here as the parties need, and happy to accept service to alleviate one issue for this court. Unless you need anything from me, Your Honor.
All right. Thank you for that. And before you leave the podium, let me just consult with other lawyers. I'm not going to ask them to examine you. That wouldn't be fair at all. But I'm going to ask them if there's anything else I need to inquire of before I let you go. Because I understand the subpoena, and we would have a formal subpoena of Ms. Hill would be placed in your hands, as her attorney. And you assure her appearance, and I appreciate that very much.
Absolutely.
Is there anything else, on behalf of, Mr. Murdaugh?
Your Honor, just in an effort to try to expedite this matter, I'd have two questions. One, will Ms. Hill meet with Mr. Griffin and I?
We'll evaluate that.
You'll evaluate it. Okay, that's all I can ask. And secondly, should we have her here on that Monday or wait? I mean, if you're going to be doing the jurors most of all
She should
day.
be here on, as court begins.
All right, thank you.
Nothing from the state, Your Honor.
All right.
Thank you, Your Honor.
I'll go over my checklist one more time, but I think I've, covered everything I want to cover. I'll come to each of you in a moment. Yes, just to clarify other witnesses, as matters now stand, the witnesses in this proceeding would be jurors and Ms. Hill. All right, so I want to be sure that we're all understanding exactly what's going on in that regard. I would not allow the attorneys to be called. I'm unclear about the mention in some of the papers that SLED investigators would be asked to testify, or any other witnesses. So I'm going to go one more time. I want to get real specific so you will understand what you need to prepare for by way of in-court examination and what you need to prepare for by way of submitting proffer. All right, first of all, for the defendant.
Police Court, Your Honor, just a couple of issues. One, we don't know who we're going to call to impeach Ms. Hill. Because we don't know what she's going to say. So it's difficult for us. I mean, once she testifies, at that point, we say we'd like to call so-and-so and so-and-so and such and such and such and such, number one. Or maybe no one. I mean, she may concede every issue we have. For instance, she did tell, according to the state, she did tell one of her assistants, one of the people helping her, I hope he's found guilty because it'll help book sales. Now, again,
I hope that's the last time you're going to repeat that until I ask for it again, Mr. Harpootman. I've told you that I can't imagine a situation in which I would go that far. So a statement like that, and she may well have said it, if it goes to anything I'm asked to consider, it would be to her credibility. And I'll evaluate whether I think that's even proper to ask, but let's move on from that.
but there are other questions concerning her credibility,
Yes, sir.
404 motive, if she did this, it is a crime. And so, the questions of why she would have done this extraordinary act, and we can argue this at another time, but in terms of me the reason I mention it is for us to proffer those people now, not knowing what she may admit. That question may get asked, she may admit it. There's no witness that needs to be called. So it's difficult for me to game this out. I don't think I've ever been asked to list witnesses I would call to impeach somebody if they lie under oath. I've never heard of such a thing, but I will attempt to do the witnesses we would call prior to Ms. Hill's testimony. That's all I think I can do, if that makes sense.
It doesn't make complete sense to me because this is not the trial of Ms. Hill. And issues about motive and so forth and the possible commission of crimes are not what this inquiry is about. It is about her contact with any of the jurors and what she said. So I will be treading very carefully with a good deal of what you say about what you might or might not ask. But I am going to ask all the parties to be pretty specific with me about what I should be asking the jurors, and I can make a decision in advance as to what I am going to do about that, and what is going to be, at least by general topic, pursued with witnesses.
Yes, sir.
And the reason I do that is because it gives me the opportunity to then consider what rulings I would make and move the proceedings along in an orderly way.
Well, Your Honor, maybe premature for me to note this for the record, but we would accept your ruling on that.
All right.
Okay. Secondly, Mr. Murdaugh has been unable to review any of the discovered material in this case because of the confidentiality order prohibits us to distribute to him while he's in jail. We don't have time in the next less than 2 weeks to go sit down with him and review everything. Would Your Honor allow him to have, and the materials are not as to the evidence in the underlying case, it's as to juror issues. And while he is no longer a lawyer, he was a lawyer at one point and can evaluate this and be of assistance to us if he has an opportunity to review that material.
You're speaking to me about something in a complete vacuum as far as I'm concerned, so I can't really evaluate what you haven't been able to review with them and what you have been able to review with them. As I understand what you're telling me is I have received certain information as the attorney for defendant that I have not been able to show defendant for defendant's review because of the confidentiality order. I can't imagine that. I think what you may be saying is Mr. Burke has not been able to keep for himself while I'm not there confidential materials.
That's correct.
That is something common to many folks who are under incarceration are limited in the kind of materials that they can receive and keep in their possession when they're not with their lawyer. This is not an issue where he's being deprived of the ability to consider material that you have received. This is a question of whether he can have that material in his possession when you are not there or your representatives are not there and study upon it and so forth. I can't control what the limitations of the Department of Corrections are, nor can I control what limitations may have been put on confidential material because of the fear that it would fall into other hands. So I'm not going to rule in the abstract on things. I would have to have something pretty specific, but I can tell you this. I would certainly not order these materials to be wholesale given to him for him to take back to his cell and have in his possession, because I don't know who might see them were that the case. And if they are confidential materials, that would be an extreme risk of breaching the confidentiality of materials to do that because of his situation. And his situation is as it is. Now, my making or yours.
Your Honor, I would only note for the record this: much of the material we've received has been within the last 2 weeks. This hearing is scheduled for 2 weeks from yesterday.
Yes, sir.
And you've given us more stuff we have to do between now and that hearing. There's nobody to go sit with him at the jail, and his time is limited as to when those people can visit. So without him being able to review this material, I don't believe we can be effective, and we would be ineffective in representing him.
Well, I understand that those are wise statements for an attorney to make to preserve your position on the record. It doesn't change my view of how we should proceed in this matter at all. I think you will be able to, if there are deficits in what you have been able to do with your client, you will place those contentions on the record, and the appellate courts of the state will have adequate chance to review.
Well, Your Honor, would you consider continuing the hearing on the 29th to allow us to meet with the client and effectively review these materials?
No, sir.
Okay.
Thank you.
We respectfully accept your ruling.
I understand.
Thank you.
Mr. Waters?
I don't have much to address, Your Honor. The initial question that Your Honor asked was about SLED agents being listed on the potential witnesses. And, Again, Your Honor, when these allegations were first raised, we instructed SLED to do an independent investigation, good, bad, or ugly. And only because of the results of that investigation, or the reason why we're standing here and litigating these issues before Your Honor. Ultimately, the only way that SLED agents could potentially be testifying, and again, when we filed our response, we didn't know exactly the parameters of the corporate rule. The only way, though, that I could see them potentially testifying is in the event that there is an accepted witness by Your Honor, that there was some sort of prior inconsistent statement under Rule 613 or some other permissible inquiry. But I think Your Honor's rulings as to the nature of the inquiry we're going to conduct would probably remove or make it very unlikely that need.
All right. Anything further?
Nothing from the state, Your Honor.
Nothing to defend, Your Honor.
All right. I say to attorneys for both sides, the court is deeply grateful for the very fine materials you have submitted so far. It's an extreme amount of work in a very truncated period of time, and I appreciate the burdens it places upon you, Mr. Hopkins, and I particularly thank you as a member of the General Assembly for not interposing your immunity because you are in session, and I respect that. I set these matters after consultation with y'all so that I could fulfill my obligations to the court as expressed in Chief Justice Beatty's order. But I realize that I'm doing that with your extreme cooperation in light of the other duties, and I appreciate it very much.
Thank you, Your Honor.
I look forward to further submissions from the parties and from the hearings commencing January the 29th. Court will be in recess.
Thank you.
Thank you, Your Honor.
Parties, what's going on? I asked Ms. Harris before these matters commenced to please expedite, even if it's in a rough form and not in a perfect form, the court would like to produce the transcript. I asked her to produce a rough copy of the transcript just as soon as she possibly could for both sides. I hope you all will consider, without me having to order, sharing the expense of this production, this early production of the rough copy of this map. She will be in touch with you. You may be in touch with her with regard to the rough transcript of these proceedings. We'll be in recess.
Thank you, Your Honor.
County prosecutor who's also been a
Will you please just indicate, just for purposes of the record, your full name?
Yes, it's Matthew Riley, Reilly. Yes, ma'am.
If I may just have a moment, Your Honor, my wire got disconnected for the television. Thank you. Your Honor, for the record, I'm calling up states 9. I believe when we left off, it would be on file 3. And photograph 8. Okay. Detective Riley, how are you?
Good, ma'am. Thank you.
Just to recap a couple questions, we can take a look at the screen behind you. Again, states 9, file 4, picture 8. And briefly, if you could just describe what's depicted in that photograph.
Yes, that's a paper towel roll that I found on the counter of the kitchen island at 69 Wells.
And the 13?
The 13 is a evidence placard that denotes it's going to be seized as State Police Exhibit 13.
And did you put that 13 there?
Yes.
Picture 9, what does that depict?
That depicts some of the blood-like stains I found on the paper towel roll.
Now, sir, did you do anything with that paper towel holder?
I field tested it for the presence of blood, ensured it was photographed and documented, and then I packaged it.
Okay, a couple questions if I can.
Yes.
When you say field test, what does that mean?
I field tested it for blood. I use a screening test called the Castlemeyer test.
No play objection.
Thank you.
And for this test, I use 2 chemical reagents, phenolphthalein and hydrogen peroxide. And
If you can just walk me through what exactly is a Castlemeyer test?
it's a presumptive blood test.
Why do you object, Your Honor, and there's been lack of foundation for this testimony?
Well, the question is, what is this field test? And the objection is,
There's a lack of foundation. This witness can, well, I think the question is, what is a Castlemeyer test? Well, I thought the question was.
If I can, Your Honor, I'll withdraw it and go back. I'm going to backtrack just a little bit. Sir, have you received any training with respect to conducting presumptive tests?
Yes, I have.
What training have you received?
I've received training both at the State Police Forensic Lab on this particular test and in one of the crime scene courses I took at the University of New Haven on other tests.
With respect to this particular test, what year did you receive that training?
Sometime in the early 2000s.
And about how many tests have you performed?
Thousands, man.
Okay. Now, asking exactly how do you perform this test?
You perform the test by taking a swab, one of those long-handled Q-tips, taking some of the material, the suspected blood, onto the swab. Then you put a drop of the phenolphthalein on it, wait a couple of seconds. Then you put a drop of the hydrogen peroxide on it. And if you get an immediate color change, it'll turn a bright pink color. That's a positive test.
Okay. Now, I'm sorry, did you say the phenol? I'm going to butcher that.
Phenolphthalein.
Phenolphthalein. Where do you get that?
I get that chemical from the State Police Forensic Lab in Meriden.
And the other item that you use?
Which is the hydrogen peroxide and the sterile water that I use as a solvent. I get those from a chemical supply house.
And are these common tools on the van?
Yes.
Okay. Are they designated in different tubes? Can you walk me through how you store those chemicals?
The chemicals are stored in a refrigerator on the van. in a, almost looks like a plastic fishing box.
Sir, about how many residences or vehicles have you processed in your career with the Western District Major Crimes Van?
Countless, ma'am.
Okay.
It's approximately 1,000 crime scenes.
And how many years were you with the van?
14, ma'am.
Okay, and how many times have you utilized that test that you were trained in?
I've utilized this particular test thousands of times.
Now, with respect to the actual process of conducting the test, can you walk us through what you do? I believe you indicated you swab the item.
Yes. So prior to using this test, I'll test the reagents on a known blood source in the van. We use horse blood or pig blood. And then for each suspected blood stain, I'll go ahead and take a swab of the suspected material. In this case, I took it from inside the cardboard tube. Put a little bit on the Q-tip, treated it with 1 drop of phenolphthalein, waited a second or two, then I put a drop of the hydrogen peroxide on.
Does the swabbing of the actual item damage or alter the item itself?
No, it does not.
Now, you mentioned you did a control with animal blood or horse blood.
Yes.
Do you keep that in the van?
Yes, we do.
Okay, why do you do that?
It validates the test. It ensures that the reagents are working properly.
Do you do that every time you use that same reagent?
At the beginning of processing, yes.
Okay. And if you were to open a new reagent, would you test it first?
Yes.
Okay. And did you do that test here on this day on May 25th, 2019?
Yes.
Okay. Now, if it changes color, what color does it change into?
It changes a bright pink.
And what are the results? What does it mean when it changes a bright pink?
It's a presumptive blood test. It just tells us that the material is presumably blood, but it doesn't tell us whether or not it's human blood or animal blood. We will get a positive test result on any blood.
Your Honor, I'm going to object now. This goes into scientific testimony, and his opinion as to the conclusion of what it shows is not based on his training or his scientific act.
Well, the response was, it's a presumptive test, and that the presumptive test is not, as the court understands the testimony, limited to human hemoglobin. And so the objection is overruled.
Is it conclusory in any way?
No, further testing needs to be done by the forensic lab.
If I just may have one moment, Your Honor. And did you conduct that test on Exhibit 13, the paper towel swabbing that you did?
Yes, I did.
And what was the result?
The test was positive.
Actually, I should ask you this, sir, if I can. With respect to the kitchen area of 69 Wells, did you seize anything else in that area?
Yes.
What did you seize?
I found another blood-like stain on the faucet.
And is that the kitchen faucet?
The kitchen faucet on that center island.
Actually going to draw your attention, sir, to the screen behind you, states 9, file 3, picture 10. If you can, just explain what's depicted in that photograph.
This is the kitchen sink faucet on that island in the kitchen. And what you see there marked by a adhesive label marked Exhibit 79, is the location of a dilute blood-like stain.
If you can, could you please, Your Honor, may I
Yes.
ask him? Sir, if you could approach the screen, please, and just point out to where you're addressing.
It's right in this area.
Okay, lower right-hand corner. I'm actually going to scroll in. If you can, sir, there's a white, I guess, ruler marking there. Did you put that there?
Yes.
And EX79, what does that mean?
That's just our designation, and it's going to be State Police Exhibit 79.
And the marking that drew your attention, is that located on the screen with it zoomed in?
This area here, ma'am?
Yes, please.
Yes.
Okay. And what did you do, if anything, with respect to that area?
This area was field tested, again, using that Castlemeyer test. And the area was marked. This is an exhibit. And then I later collected a sample of this stain with 2 swabs that were moistened with sterile water.
Okay. Couple of questions on that. You tested it utilizing the same procedure that you just testified to?
Yes, it's always the same procedure.
Did you wear gloves while you did so?
Yes.
And any other protective gear?
Just gloves.
Now, with respect to the Castlemeyer, can I call it KM?
Yes.
Is that okay? With respect to the KM test, what was the result?
The test was positive.
And you indicated you took 2 swabbings. Was that after the test or before?
After the test.
And why 2?
We take 2 swabbings just for more sample, to collect more sample.
With respect to this kitchen sink area, did you take any more samples or seize anything on the sink faucet?
Yes, up in this area here, we found another dilute blood stain.
Picture 11,
Yes.
if you can, sir. Could you please point out where and what you see in that photograph?
Yes, this is the dilute blood-like stain we found.
What did you do, if anything?
Again, the area was initially field tested using that KM test. The test yielded a positive result.
Could I just have a continuing objection so I don't have to keep interrupting on this issue with regard to the presumptive?
Thank you. Overruled.
And following the test, I marked it as Exhibit 14 and later collected it with that same process of utilizing 2 swabs.
And with respect to the kitchen, sir, anything else in the kitchen area?
Yes, they're down below in the cabinet underneath the sink. We found some items of interest.
States 9, picture 12. What does that depict?
This depicts, looks like Exhibit 15, which was a blood-like stain that we found on the handle.
Sir, if I scroll in there, do you see, if you could point out, or is that blood-like stain shown on that?
Yes, it's this area here.
What did you do, if anything?
Again, it was field tested with KM. Positive test result. It was marked, photographed, and collected with that same 2 swab process.
And it says EX15. What does that mean?
State Police Exhibit 15.
Thank you. Now, inside, I see there's a yellow placard, 17. What does that mean?
We found 2 items of interest in there
Actually,
inside the cabinet.
if I can, I'm gonna go back one, actually, if I can.
Sure.
I'll just show you 14. If I can, states 9, picture 14, please, in file 3. You can explain what that photograph depicts, please.
The 2 items of interest that we collected from underneath the sink were Exhibit 16, which was a pair of latex gloves, and Exhibit 17, which was a box of white plastic trash bags.
Did you make the decision to seize 16?
Yes.
Why?
The gloves had a texture to them, they're dishwashing gloves. And I previously on our walkthrough, we found a blood-like stain pattern in the garage on the floor that appeared to be a glove print. And the print appeared to have some sort of texture to it. It was somewhat similar to these gloves here.
And the 16, is that, what does that delineate?
Again, State Police Exhibit 16.
And 17?
17 is the box of hefty trash bags.
Did you make the decision to seize those, sir?
Yes.
Why?
Just because we found what appeared to be evidence of cleanup inside the garage. So, it was, we assumed that possibly one of these trash bags may have been used. And if found, maybe they could match it back to that box.
What day did you collect this evidence?
This was collected on May 25th of 2019.
Thank you. Anything else in the kitchen that you seized or swapped that day?
We found another blood-like stain up on the edge of the countertop.
Can states 15. What does that depict, sir?
Again, that's the this blood-like stain here. That's discoloration.
And what did you do, if anything?
We field tested it for blood using that KM test. It was positive, and then we collected it using that same swabbing method.
2 swabs as well?
2 swabs.
Okay. I want to show you what's marked as states 16. I'm sorry, it's actually states 9, file 3, states picture 16. What is that?
This is a toothbrush that I found in the master bathroom upstairs on the 2nd floor.
And there is a yellow placard 31. What does that mean?
We seized that as State Police Exhibit 31.
Why did you seize a toothbrush?
In missing person investigation, we attempt to collect a pseudonym or something that a pseudonym DNA profile can be developed from. We do this by either collecting the missing person's toothbrush or razor, something of that nature.
By missing person, do you mean Jennifer Farber-Dulos?
Yes, ma'am, Jennifer Dulos.
On May 25th, 2019, did you collect anything else from the house?
Yes, several other items.
You can have a seat, sir. Actually, I'm sorry. I'm going to show you what's been marked as 17. Actually, it's 9, file 3, picture 17. What is that?
That is a hair that we found on the garage floor.
Now, you indicated you did not process the garage on 525. Did you take this out of the garage on 525?
Yes, I did.
Okay, why this item?
Because the hair was loose and it could have easily blown away.
If I can, I'm just going to scroll up. Is the hair depicted in that photograph?
Yes.
Now, with respect to, actually, I apologize, strike that. And I'm going to show you what's marked as picture 18. What is that photograph?
That is one of the seals that we use to seal up the house at the conclusion of processing on the 25th. That is on the, appears to be the central garage bay.
That red tape that's depicted in the center part of the photograph, did you put that anywhere else in the house?
Yes, on the garage bay doors and the front door. And
Do you recall any other ones?
not off the top of my head, ma'am.
Okay. With respect to, oh, yes, actually, right above the red tape, right, that the gray marking, what is that?
That's a garage door remote.
Okay. And did you take any action with respect to that?
Yes, on the 25th, I swabbed that in an attempt to collect any latent DNA material that may have been on it.
Okay, did you use that same two-swab process?
Yes.
Thank you. Now, on the 25th, did you, again, why didn't you process the garage on the 25th?
Our plan was to call in a bloodstain expert to come in to process the garage with us.
And who did you call?
It was then Lieutenant Mark Davison.
And what day was he scheduled to process the scene with you?
Objection irrelevant with this witness.
Well,
And
the
here's-
question is, on what day was he scheduled to process the scene? And the objection is relevant, overruled.
He was scheduled to come on the 27th, which was Monday.
Now, did you go anywhere else on May 25th?
Yes, I did.
Where did you go?
In the morning, I went to Lapham Road in New Canaan.
Okay, sir, I'm gonna have you take a look behind you. This would be States 9, File 5, Photograph 1. Do you recognize what's depicted on that photograph?
Yes.
What is it?
That's an overhead view of the area of Lapham Road that I visited on the morning of the 25th.
If you could, would you mind standing up and just pointing to the area that you visited that morning?
It was generally in this area here.
Why did you go there? You can have a seat, sir.
Well, before you proceed, counsel, would you just indicate for the record what quadrant of the photograph
Oh,
the witness pointed to?
I apologize, Your Honor. For the record, that would be the middle to lower center right area. Is that correct, sir?
Yes, ma'am.
Thank you.
Thank you.
Now, why did you respond there?
We learned that the New Canaan Police Department had located Jennifer Dulos's Chevy Suburban on that road, and that they were going to be in the process of towing it back to their police department. We wanted to go there first to take a look at the outside of it, photograph it before it was loaded onto the tow truck.
What time did you go to Lapham Road that day?
It was in the morning, approximately 7 o'clock.
What did you do when you arrived on scene?
I looked at the outside of the vehicle and then photographed four sides of it.
Did you walk around the entire vehicle?
I believe so, yes.
And with respect to, well, if I can, I'm going to show you, you take a look behind you. This is again file 5, States 9. Picture 2, do you recognize that photograph?
Yes.
What is it?
That's the photograph of the Chevy Suburban I was speaking about.
Did you take that photograph?
Yes.
Now, with respect to walking around the vehicle, how close was it to the, I guess, foliage and trees next to it?
I believe the right-hand side of the vehicle was right up against the bushes.
And the right-hand side, would that be the driver's or the passenger side?
I'm sorry, the passenger side.
Thank you. And the direction of the vehicle parked, I guess, is that, actually, if I can just go back briefly to picture 1. Sir, do you know what road is on the bottom here going from left to right?
That's the Merritt Parkway, Route 15.
And with respect to the vehicle, how it was parked, do you know which direction it was facing? Was it towards or away from the Merritt Parkway?
It was facing the Merritt.
I'll show you picture 3. What does that depict?
That's the left or driver's side of the vehicle.
And picture 4.
That's the rear of the vehicle.
Now, were you able to walk around the vehicle over here on the right side? You can see my cursor.
Not completely. I really just kind of had to look from, where I could access.
And did you find anything on that vehicle that you took note of?
I found some blood-like stains on the outside of the vehicle.
Where?
On the outside of the vehicle.
Okay, and where on the outside of the vehicle?
I believe it was on the rear bumper.
Did you photograph them?
Yes, I did.
Or I should say, I'm sorry. 5, states 5, what is that?
That's one of the blood-like stains I found on the vehicle.
Now, if I scroll in, it does not have, this photograph doesn't have a writing here. Did you put that white, I guess, measurement marker that we've seen?
Yes, I did.
Okay. There's nothing written on it. Is there a reason why?
I just included in the photograph for scale.
Did you process or take any action with the vehicle as it remained on scene?
No.
And what does 6 depict, please?
Again, that's another view of that same stain.
Now, so I'm going to draw your attention back to May 27th. Well, actually, before I go there, I'm sorry, strike that. The evidence that you collected on May 25th, I think we went through some of them, the swabbings, the 13 through, I forget the number now. What happened to the evidence after you packaged it and gave it a evidence number?
The evidence was sealed, and I labeled them appropriately per our protocol. Some of the electronic evidence was turned over to the New Canaan Police Department so they could pursue those items, examine those.
With respect to the items that you were shown photographs of, what
Yes.
happened to those?
I secured those in the major crime van. And at the conclusion of processing, I drove those up to our headquarters in Litchfield, secured them in the evidence room. And then on the 27th in the morning, I returned to Litchfield, took them out of the evidence room, put them on the major crime van, and drove them back down to New Canaan.
Why did you do that?
Because they were still in our custody.
Okay, and was it a state police case at this point?
I'm not sure when that changed, ma'am. We wanted to keep the evidence together, and normally we turn over evidence to the local police departments when we do an assist all at once.
Okay. And on the 27th, did you drive the van to 69 Wells that day?
Yes.
And in the van, is there a place to store the evidence?
We usually keep it in a banker's box on the floor.
And when you arrived at 69 Wells Lane on May 27th, who was there?
A lot of the same crew from the 25th was there, with the addition of Detective Jamie Pierston and Lieutenant Mark Davison.
And between 525 and, well, strike that if I can, that photograph we showed you with the red tape
Yes.
on the doors, was that in the same location when you arrived back on 527?
Yes.
Was anyone from New Canaan Police Department on scene on 527?
They had posted a uniformed officer in the driveway.
Did you see anybody from New Canaan Police Department go into the residence with you that day, or not with you? Did you just see them?
Yeah, they were just in the driveway, ma'am.
Did they enter the garage?
Not while we were processing it.
Now, on May 27th, did you process any other area other than the garage?
Yes, we again continued to look through the rest of the house. In addition to the garage, we also did a latent print exam in various areas of the house.
Did you do that before you processed the garage or after?
It was pretty much ongoing. However, the latent print exam was probably one of the last things we did.
Why do you do that as part of the last things you do?
Because we use standard fingerprint powders and it really makes a mess.
All right. Was in the processing of the garage, was the garage, I guess, divided up?
Yes, we came up with a grid system just to make documentation easier. We laid out a grid with yellow tape similar to masking tape that has measurements on it. And we gave them letter designations, A, B, C, D, all the way up to G.
You mentioned Detective Pearson was present with you on 5/27. What was her assignment?
Her assignment was to create a sketch map of the garage.
Have you reviewed those sketch maps, sir?
Yes.
I'm going to draw your attention to the screen behind you. I am in States 9, File 6. And actually, if I may. Do you recognize what's depicted on the screen behind you, sir?
Yes, that is one of the finished maps that Detective Pearson created.
Did you have a particular process or procedure you conducted throughout the garage that day?
The garage was examined, for evidence along with the documentation done by Lieutenant Davison. We kind of worked it together.
Now, I'm going to ask you a couple questions, starting with garage A, marked A, if I can. Do you recognize the map behind you, sir?
Yes.
Okay. With respect to the letters and numbers that are printed inside of A, for instance, A18, A17, A16, what exactly are those supposed to designate?
Those numbers are for individual stains that Lieutenant Davison designated for his examination.
And the EX numbers or the EX letters?
Right, so those were samples that I took for DNA identification purposes. So Lieutenant Davison was examining the blood stain patterns, and in his examination, he selected stains, gave them those letter designations, and from each stain pattern, I chose one and collected it.
Why did you only choose one?
Really, it's just to get a representative DNA profile from that stain pattern or region of the garage.
And as you say, you chose one. What did you do? I mean, if you could walk us through the process briefly.
Using the same method that I used on the previous blood-like stains, I field tested it with a KM test. Noted that, whether it was positive or negative, and then using that two swab process with swabs moistened with sterile water, I collected the stains.
I can just have a moment. It is. So just a couple questions if I can. If you can take a look behind you. Showing the map on the left, but on the right side, it's photograph 2 out of file 6 on States 9. What does that depict?
That depicts the photograph, an overall photograph of Area A. and corresponding overhead view on the sketch map of Area A.
Was that prior to processing?
This was in the process. This was the beginning of that examination.
And I'm actually gonna bring that back down. Okay, picture 3 of that same file. Sir, what does that depict?
Again, that's just another view of Area A.
If I can, just draw your attention and ask you some questions about these. There's a sort of like an upside down L-shaped file. What is that there for?
That's to help give scale to, may I approach the
If you
screen now?
can, thank you.
So you can see this discoloration here. That appeared to us to be white mark, where maybe some blood-like material was on the floor, and there was an attempt made to wipe it up.
Can't hear.
I'm sorry, sir, if you can, just move that microphone behind you, maybe up a little. The one. Thank you. And the yellow arrow up on the upper middle part of that photograph, what does that depict?
That's usually placed by the photographer to denote the north.
So it's directional?
It's directional, correct.
And this yellow marking, is that the yellow marking you were talking about before?
Correct, that's that yellow masking tape I was talking about.
Okay. Now, with respect to these 3 items, did you put those down?
No, I did not.
And over here on the right-hand side, we have that same, I guess, ruler marking. What does that depict?
That's that same L scale is being used to denote another stain pattern found on the garage floor.
And is that,
close to the wall.
oh, I'm sorry. Is that for documentation?
Yes.
Now, with respect to the rest of the garage floor, there's these little dots here all over. I'm gonna push the photograph up if I can. All these little markings. What are those?
I mean, it's a garage floor, so you have plant material, you have you know, other types of vegetation, you have sand, road salt.
Now, I'm going to show you picture 4, sir. In that same file, what is this?
This is part of Lieutenant Davison's examination of the garage floor.
Were you present when these markers were placed down?
When they were placed down, no, but I was I observed these in place.
And just to go in, what do they read, please?
They read A12, A13, A14, and A15 with my marking of State Police Exhibit 40.
And this is this corresponding on the map on the left-hand side of the screen?
Yes, in this area here.
Okay. And with respect to states 40, did you utilize that same 2-swab process in swabbing it?
It's the same process. It's first KM tested and then collected with the 2 swabs.
And the KM test?
Was positive.
And just to clarify, this is which one is what is this depicted?
That is stained A12.
Okay, if you can, sir, I'm just going to show you a series of photographs. If you can just point to the sketch map just to correspond where they are located. If you can.
A12.
Thank you. Now state 6.
A13.
State 7.
A14.
And states 8.
It's A15 where Exhibit 40 was sampled.
Is that the area that you swabbed that day, sir?
Yes.
Thank you, that's state sign. With respect to these areas, did you mark these or delineate these in any way?
I did not place those scales.
Now, with respect to this area, if you could tell me what this is?
This is a photograph taken overhead of stains denoted as A16, 17, and 18, along with exhibit 41, which is in this area here.
Now, just briefly, if I can, I just want to be clear, with respect to A16, 17, and 18, do you recall viewing those that
Yes.
day? Okay. And you took a swabbing off of which one?
Off of stain A18.
Okay, which is up here, right?
Correct.
Who took the photographs that day?
It was Detective Katie Keppel and Detective Bob Hazen.
If you can, sir, same question, series of photographs, if you can just point to the screen where.
This
it
is stain A16, A17, and A18.
Do you recall, by the way, this is kind of leaning, I guess, angled one way. And then I'm going to draw your attention to the preceding two photographs, 17 and 16. Actually, I'm sorry, it's photographs 12 and 13, but A16 and A17. They're leaning the other way for the photographs, and the overview has them this way. My question is just, which way are they supposed to be?
The scales were not moved, if that makes things easier. The photographer is probably just standing on one side of the stain or the other.
In the course of the photography and processing scene, do the scales ever move?
Not on the garage floor in this case.
And I believe we went. And actually, did you review the part designated as garage B? And if I can, sir, do you recognize what is depicted on the screen there?
Yes, that is another.
Oh, I apologize, I hit the wrong.
Sure.
Button. There you go.
And that is the another part of the left side garage bay in the center of the garage.
Is the photograph 1 on states 9, file 7, photograph 1, is that area depicted on the, or is, I should say, the map, a depiction of an area on that photograph?
Yes,
If you could just point it out on the photograph, please.
it's this area here. You can see the B placard right there.
And for the record, that was the middle portion of the
The
photograph?
middle, correct.
Okay, now on this, we have, on the map portion, we have the numbers ranging from B3 all the way up to B11. Is there a B1 or 2?
That I don't know.
And states picture 2, does that depict an area depicted in the map?
Yes.
And states 3.
Yes, that's the right-hand side of the map.
Okay. States 4, what is on that photograph, please?
That's a fragment of paper towel that appeared to have blood-like stains on it that we found in Area B of the left-hand side of the garage. And it's located right there on the sketch map. It is Exhibit 42.
For the record, you're pointing to the middle portion of the garage. Question about the, well, sorry, withdraw that. With respect to the 42, that paper towel, can I ask you to describe some of the, I guess, dots that are contained in the 42? What exactly did that appear to be to you?
Yes, this material here appears to be plant-like, part of seeds or.
Did you take any swabbings of 42?
I did not,
Why not?
because I just seized the entire fragment of paper towel.
How did you seize it?
I put it in either a paper bag or a paper envelope.
Did you seize anything else out of that area B?
Yes.
What did you seize?
There were two stains. B3, I took a sample of, is Exhibit 38. B11, I took swabbings as Exhibit 39. And Exhibit 43, which I believe was another paper towel fragment.
Picture 5. What does that depict, sir?
Okay, that's another paper towel. It's a larger paper towel fragment with apparent blood-like stains. You can see this reddish staining here.
What did you do, if anything, with the 43?
Again, I just ensured it was photographed, sketched into the map, and I seized in a similar manner as 42.
Did you take any swabbings?
I did not.
And if you can, sir, is what's on picture 6 depicted on the map as well?
This was the stain designated as B3 that I took swabbings of as Exhibit 38.
And did you do any testing on Exhibit 38 as well?
I did a KM test.
And the results?
Positive.
Now, what does this depict, sir?
That is stain B4, located there.
And for same questions for the next couple, if you wouldn't mind just pointing out where it appears on the map corresponding with the picture. So picture 8, B5.
B5 is here.
Picture 9, B6.
B6.
Picture 10, B7 and B8.
B7, B8.
Picture 11, B9.
B9.
Picture 12, what does that show, sir?
So that is stains B9, B10, and B11, which are up in this area here. A sample of B11 I swabbed as Exhibit 39.
And that is, if you, okay, and the same swabbing process, same every?
Same swabbing process that was also tested with the KM test that was positive.
Now, picture 13, what is that, sir?
That is, appears to be one of those blood-like stains, that slink mark that we saw up in Area A.
And is this depicted on the map in any way?
I don't believe so.
Was that contained in Area B at all?
Without seeing an overall shot, I really can say that.
Okay, let me see if I can. Here's the overview. Does picture 1 assist you in any way? And if it doesn't, that if you could just say that.
It's hard to say that.
Okay. Now I'm going to ask you if I can about the bottom part of that garage side. You could take a look. Are you familiar with Detective Pearson's map for C?
Yes, this is the portion of that left garage bay closest to the door.
And for the record, I'm going states 9. I am now in file 8.
I'm still here, guys. We're still watching the trial.
File 8, picture 1. What does that depict, sir?
That depicts that left garage bay.
Please leave your message.
And area C is in kind of the closest to the driveway. It's this area here.
And for the record, he's pointing towards the middle bottom portion of the photograph. Picture 2. What is that a picture of, sir?
Those are some more of the blood-like stains we found on the garage floor.
And the yellow arrow again?
Again, denotes north.
Picture 3. What does that depict, sir?
That is area C with some of the stains and exhibits marked up.
We have the 68 placard right here. What is that supposed to be?
That designates another fragment of paper towel.
Is that depicted on the photograph?
Yes.
What did you do, if anything, with 68, please?
I collected it in the same manner as the other fragments of paper towel, packaged in paper.
Did you take any swabbings?
I did not.
And if you can, sir, picture 4. And if you wouldn't mind, the same thing, just if it is reflected on the map on the left side, if you could.
Stop, please.
Oh,
What has just happened, ladies and gentlemen, is that, of course, the entire proceeding is recorded. The recording system just went down. So what we would ask you to do is just return to the deliberation room. Please do not discuss the case. We're going to take our morning recess until 11:30. 11:30, Mr. Marshall.
All right. Son, will you very close now?
eat out of food. Think of you. She keeps me under the spell. She keeps me under the spell. This is my kingdom. When I was younger. I wonder who's the only person here.
Contained in area D.
Yes.
And picture 9.
Yeah, it's the additional stain pattern found in area E.
If I can, I'm gonna scroll. Oops. Up here, this marker, I guess L-shaped marker again. What is that?
Again, it's another blood-like stain on the floor.
Well, thank you. Thank you for your
With,
support, Sean B.
Similar pattern, but a lot less detail to it.
Appreciate it.
And with respect to these items just around, and if you could follow my cursor, sir, they're little dots or things. What are they?
It could be vegetative matter, plants.
And anything, actually, picture 10, was this contained in area D?
Yes. Right here at the, almost at the border of area E.
And is this the same item that you seized on 525?
This is correct. This is the error.
Now, with respect to States 9, File
I
10.
think I'll get my hours before I get my viewers.
So are you familiar with Detective Pearson's map for Area E?
Yes.
Sir, photograph 1 out of that file, does that depict?
It's an overall view of, again, that right side garage bay. Area E is depicted here right in the center.
Photograph 2, what is that, sir?
This is a blood-like stain pattern that is located in area E. It's located here, kind of top center of the area. And I took a swabbing of this area to sample the blood-like stain. It was on the garage floor.
Was that designated as a exhibit?
Yes, exhibit 51.
There is a pink arrow on the right side. Do you see where the pink arrow is?
Yes.
What exactly is that?
That, in this large stain pattern, the arrow depicts exactly where I took the sample from.
And same process, 2 swabs?
2 swabs, yes.
Did you test it?
I did.
And the results?
Again, every now and then, just make the same objection regarding any quote results.
Thank you, overruled.
The test result was positive.
Thank you. Sir, picture 3.
As a similar stain pattern, another blood-like stain appeared to be a white. It's located here at the left-hand side of area E. And again, I sampled this using that same swabbing technique, same testing technique. And I took the sample from this area here.
And the test results?
Test results were positive.
Picture 4?
Picture 4 is another blood-like stain we found in area E. And the stain pattern itself appeared to us to be a textured glove. If you can imagine 3 fingers here.
What exhibit was this marked at?
I marked it as State Police Exhibit 55.
And states 5. What does that show?
That's an overall view of area E taken from kind of with your back to the mudroom door. So you can see exhibit 55 here, that swipe mark.
And picture 6?
It's an off-kilter view of area E and the right-hand side of the garage.
Thank you. I'm going to draw your attention now to states 9, file 11. Are you familiar with Detective Pearson's map concerning zone F?
Yes, I am.
Picture 1 off of states 9, file 11. Sir, what does that depict?
It's an overall view of the right-hand side of the garage. You see area F is down here. This is the kind of threshold of the overhead door. And area F is up in this area. Makes up center all the way down to the bottom of the photograph.
Thank you. Picture 2.
It's another blood-like stain pattern we found on the garage floor. Again, this is the threshold of the overhead door.
I'm going to scroll in a little bit. So that yellow arrow again, what does that depict?
That denotes north.
Picture 3.
That is, again, another blood-like stain pattern we found on the floor. Again, there's more detail inside this pattern. So we designated it as State Police Exhibit 54, photographed it in a similar manner as the others.
And is that depicted on the map?
Yes, it's located on the left-hand side of area F.
Picture 4.
Picture 4 is another blood-like stain pattern found on the floor.
And picture 5.
That is blood-like stain that I tested and sampled as Exhibit 52.
And with respect to the swabbing process, same swabbing process?
Correct, same testing and swabbing process.
And the test results of this one?
I referred my report.
Would it refresh your recollection to take a look at your exhibit report?
Yes.
Can you just approach the clerk and smart ID? 11 for ID, please. Sir, would it refresh your recollection to take a look at your exhibit report?
Yes, it would.
I'm going to hand you and draw your attention, please, to page 3. Please take a moment, do not read that out loud, and look up to me when you're done. Did that sufficiently refresh your recollection, sir, as to the results of the test?
Yes, it did.
And what were the results of the test?
That KM test was negative.
Thank you. that depicted on the map as well?
Yes. Exhibit 52 is there.
Thank you. And state 6, or picture 6, I should say. What is that?
Yeah, that's another overall view of area F.
Are you familiar with area G, sir?
Yes.
And now states 9, file 12. Are you familiar with Detective Pearson's map?
Yes, I am.
Photograph 1, sir, what does that depict?
That is a photograph of the center garage bay, 69 Wells.
And is area G contained in that photograph?
Area G is in the area in which the Range Rover is parked, so it's in this area here.
Photograph 2?
Photograph 2 are some blood-like stains found in area G up in this area. And for orientation, this is the step into the mudroom.
Now, what are the, were exhibit numbers given to each of these stains?
The stains that I sampled, yes.
Okay. With respect to exhibit states picture 3, what is that, sir?
That is a stain we sampled as exhibit 47.
Is that reflected on the map?
Yes.
And when you say sample, did you conduct the swabbing process that you
I-
testified to earlier?
I did.
And the test, any test?
I did test that, and there were some stains up in this area that tested negative. And just from this, I don't remember which ones were which.
Would it refresh your recollection, take a look at your exhibit report again,
Yes.
if I may? So I'm going to draw your attention to page 2 of your exhibit report. If you could please just take a look.
Still here.
Sir, did that refresh your recollection?
Yes.
And with respect to the presumptive test that was performed on exhibit 47, do you recall what the results were?
The KM test was negative for this stain.
In 48,
Negative.
48 was another blood-like stain in the same general area. It's right here by the stairs. Again, I sampled that and tested it and sampled it in a similar manner.
and the results of that one?
Yeah, I'm not sure of either.
If I can, if I may just have a moment. Your Honor, if I can, I'm just going to provide Detective Riley with 11A, or I'm sorry, 11 for IV, which is the exhibit report. Sir, if you can just take a minute and take a look at that, if you can, to refresh your recollection with respect to the results of any testing performed on exhibit 48 on 527.
Yeah, the KM test for exhibit 48 was positive.
49,
49, another blood-like stain located up here in the same general area. It was tested and swabbed, collected in the same manner as the others. And the test result for this stain was negative.
and picture 6.
Again, another blood-like stain on the garage floor, located here. I sampled it, tested it, sampled it in the same manner when and the test result was negative.
Picture 7.
Picture 7 is a fragment of paper towel found under the left front tire of the Range Rover. See it, it's located here.
Did you take any action with respect to that?
After it was photographed, I just collected it now.
Well,
Picture 8.
Is a photo of low-light stain. Again, it appears to be a swipe located in area G. A sample of which was seized as Exhibit 45. It was tested and collected in the same manner.
Do you recall the results?
The test result for this stain was positive.
Picture 9.
That is a stain pattern. It was designated G20 for a light stain. A sample of which I see is Exhibit 36. I tested it and swabbed it, collected it in the same manner, and the test result for this was positive.
Picture 10.
As a stain marked as G19, located in area G, that I tested, swabbed, and collected the same manner. And test result for this was positive.
Picture 11.
That's the, this is a picture of the stain pattern found in area G after, I'm sorry, 2 stain patterns found in area G. And this photograph was taken after the Range Rover was removed.
Actually, going to go down to and what does this photograph depict? So it states 18.
This was a photograph along the process of Lieutenant Davison's examination of the flood-like stains on the floor.
If I may just have a moment, Your Honor.
Yes.
let's go.
Have on a separate disc 10.
Wait, what are you up to?
There's no objection to it. If I may just have a moment to switch it out.
Yes. No objection, Attorney General.
No objection, that's correct.
Stage 10 will be admitted as a full exhibit.
Sir, were you present when the Range Rover was removed from the garage?
Yes.
And did you conduct further processing of the garage scene with the Range Rover removed?
Yes.
If you can just take a look behind you, sir. This is states 10, filed 16. Can, what does that depict?
Appears to be a bull-like stain, that swipe pattern, sample from area G.
And
We brought the exhibit number. Yes, this was tested and sampled and seized as State Police Exhibit 45.
And just to be clear, the same process, same everything?
Yes.
Okay, results?
The test results for this was positive.
And at some point, the Range Rover was removed. Who removed it from the garage?
I believe we just towed it out of the garage, winched it up on a flatbed.
Okay. And did you continue processing the garage floor after the vehicle was removed?
Yes.
I'm going to turn your attention to the photograph 2. What does that depict?
That depicts the 2 stain patterns that would have been underneath the Range Rover. One here in the lower part of the photo, and one here a little bit higher.
Just scrolling in. So does the higher one appear on the screen?
Yes, up in this area here.
Okay. Now, what does picture 3 do?
That is the selected stains that were designated as GW1, GW2, GW3, GW4, and GW5.
And sir, what does GW mean?
Area G, I'm not sure what the W stands for. That would be Lieutenant Davison's area of expertise.
And were these I'm going to show you a series of photographs, please. You just indicated some numbers. Are these the ones that correspond to the numbers that you marked?
Correct.
Okay, that would be for the records for photo, sorry, 8, 7, 6, 5, and 4. Are photos 4 through 8 depicted in photo 3?
Yes.
Okay. Now, photo 9, what is that, sir?
This is that upper stain pattern in area G. It was seen in the overall photograph. Here you have stain GE1, GE2, GE3, GE4, and GE5.
And just briefly, you could take a look at 10. What does that depict, sir?
That stain designated as GE1.
Could you point to the, okay. And for the record, it's the middle of the photograph?
Center of the photograph, correct.
Thank you. Picture 11.
This is stain GE2 in the center of the photograph.
Is this oriented like this picture? Sir, if I can, back to.
So you can see the elongated stain here.
Okay. So
The elongated stain here.
which way is it on the garage floor? Is it perpendicular or I guess parallel?
So if you turn this photo clockwise, they would align.
Okay.
It was just taken from a different angle.
Picture 12.
Stain GE3 in the center of the photograph. Stain
Oh, and
G.
I apologize. Same question with respect to GE3.
Similar, the scales did not move.
Okay. And GE4?
GE4, again, the stain in the center of the photograph. And the scale did not move from the overall.
And GE5?
G5, similar. Is this elongated stain here? And again, it's oriented, the scale's in the same position in the overall photograph.
Just safe to say it's the way the photograph was done.
Exactly, it's just the way the frame was taken.
And picture 15, please.
15 is a photo of a stain on the garage floor. Appears to be a tire mark.
Thank you. If I may, Your Honor, the state's going back to states 9. States 9, file 13. Sir, what does that depict?
These are the garbage cans that were found inside of the garage at 69 Wells. They were in the corner of the right-hand bay. The garage door would be on the right-hand side of your photograph.
And did you find anything of evidentiary value on the garbage cans?
Yes, there were blood-like stains found up and around the lids on both garbage cans.
Photograph 2, what is that?
That is a photograph of the left garbage can.
And photograph 3.
Again, that appears to be the left garbage can. And you can see the blood-like stains both here and here.
Photograph 4.
That is a photograph, I refer to my report to get left to right.
If it would refresh your recollection,
Yes.
please.
That was a photograph of the left-hand garbage can that you saw in the overall photo. This was taken during the evidence collection process. And it was tested, swabbed, and collected as State Police Exhibit 66 from this area here.
Were there other swabbings that were taken out of the garbage cans?
On the right-hand garbage can. So as the right-hand garbage can, again, in a similar area, found a blow-like stain.
And with respect to the garbage cans, about how many stain or swabbings did you take in all of the left garbage can? If it could refresh your recollection to go to your report, please.
Still the same, 2 swabs.
And with respect to the right side garbage can?
2 swabs.
And were those also tested?
Yes,
And the results?
positive.
Now, sir, did you all have an opportunity to examine the Chevy Suburban that you, or be part of the processing of the Chevy Suburban that you earlier in the day had gone to Lapham Road to
Yes.
examine? You can have a seat, sir. When was that?
That was on June the 28th, so it would have been the Tuesday after Memorial Day.
And actually, prior to leaving 69 Wells that day on May 27th, 2019, you testified earlier about latent prints. Did you conduct any latent print documentation?
Yes, we did.
I'm actually going to go to States 9, file 4. Where did you take latent prints from?
Well, we searched for latent prints around the points of entry.
I'm going to object as non-responsive.
Okay.
Well, the question is, where did you take latent prints from? And the answer was, we searched for latent prints. It is non-responsive.
I will ask some foundation questions, sir. What exactly is a latent print?
It's a, lack of a better term, an invisible fingerprint. A fingerprint that's deposited on a surface that needs some sort of development to make it visible.
And is there a process that you utilize in searching for these?
Yes.
What is that process?
Process is visual observation, utilizing side lighting, different lighting techniques. And then in this case, it was the application of just standard fingerprint powders.
And how does fingerprint powder allow you to search for latent prints?
The fingerprint powder is extremely fine and it adheres to the fingerprint residue and makes the print visible.
And did you conduct that process at 69 Wells?
Yes.
At what locations?
Various locations throughout the house, the first floor, in and around the points of entry, around the mudroom door, around that the kitchen island.
I'm going to show you some photographs, sir, if I can. If you could take a look behind you, states 9. This is file 4. What do you see, sir, depicted in that photograph?
That's an overall photo of the door leading into the mudroom from the garage after latent print processing and prior to the collection of the prints.
And well, actually, I'm sorry, I went too fast. If you could, would you mind standing up?
Sure.
And going back to the screen? Thank you. Couple questions, sir. Where is all on that photograph, if anywhere on that photograph, you mentioned the black powder, fingerprint powder. If you could just describe it for the record, please.
Right, it's this dark colored smudges all over the white door.
Did you put that on there?
Yes, I was one of the people who searched for latent fingerprints with
I'm going to check this non-responsive. It's either he did it or it was one of the people.
Well, question was, did you do that? He said he was one of the people. The court understands parenthetically who did it. Overruled.
What is the process for putting that fingerprint powder on a door such as this?
We have special brushes that we use that we put the fingerprint powder on and apply it to the surface. And sometimes the fingerprints readily appear, become visible. Sometimes it takes a little bit of work to clean up smudges and things like that with the brushes.
And how would you do that? Clean up smudges, or what do you mean by that?
Oh, you just, if, to get more detail out of the print, you'll work it with finer brushes, smaller brushes, and try and clean out the fingerprint powder from in between the ridges that you see on the print.
Did you develop any latent prints out of the mudroom door?
Yes.
Where?
Right here above the lock cylinder.
Show you what's been marked as states. Picture 2. Sir, what does that show?
So this is the latent prints prior to collection, prior to lifting them.
And what do you mean by that?
So we will take photographs, obviously, to try and pick up the detail. And then once that's completed, we'll go ahead and take adhesive lifters. Usually it's adhesive clear acetate, almost like tape. In this case, down here, we used a gelatin lifter, which is a thin layer of gelatin on a rubberized backing. It's just used for different surfaces.
And the markings on the measurement tape, or the white stickers, I should say, what exactly does that mean?
So the LP stands for latent print. So we run them sequentially. So this would be
Your
latent
Honor,
print.
again, I'm going to object unless he's referring to himself in the plural. I would ask that he please clarify whether he did this or someone else did it, just for clarification.
So the question, as the court understood it, is not whether he did it. He was asked to explain what those designations mean, if the court understood it correctly.
That was the state's question, Your Honor.
Overruled.
So this is my handwriting on the markings. So LP stands for latent print. Latent print 7, which is also designated as State Police Exhibit 82. Here, LP 8, latent print 8, State Police Exhibit 83.
Did you go anywhere else in the house and conduct this process?
Yes.
Where?
The kitchen of the residence.
And with respect to the mudroom door, is this the side going into the garage or the side going into the kitchen?
So this is what we designated as the exterior side. So this is the garage side of that mudroom door.
Picture 3, do you recognize what's depicted in this photograph?
Yes, this is the area around the inside face of the mudroom door. You can see down here where I had removed the doorknob. So this is one of the casings. You see LP1, late print 1, exhibit 73. Above that, latent print 2, exhibit 74. And down on the wall, exhibit 75, which is latent print 3.
The blue writing, is that actually on the wall?
Yes, I did that with grease pencil and China marker.
Why would you do that?
That designates which one I'm actually looking at, or what the actual lift is. So, and it just depends on the amount of detail in that print. So in a photograph, if I just put up a scale, I don't know which one of these is the exhibit. That's why we circle it with the China marker, and the arrow just orients the print. And then sometimes that gets picked up on the lifter itself. So it's more for the examiner.
Did you search for latent prints in the kitchen area?
Yes, I did.
Where?
Mainly around the kitchen island, where I found those other exhibits.
Show you what's been marked as picture 4. Do you recognize what's depicted in this photograph?
Yes, that's the inside of one of the cabinet doors.
And if you can, that same blue writing is on there. If you could explain that, please.
Correct. That's I marked out the print in blue China marker and designated it as latent print 4, exhibit 76.
Show you what's been marked as states 5. What does this photograph depict, sir?
That is on one of the entry doors. May I refer my report to?
If it would refresh your recollection, please.
Okay, this is the French doors leading out to the backyard, the rear patio.
And if you could walk me through, did you do this one?
I'm not sure if I dusted this, but I designated it and marked it up.
And if you could just walk me through what you did.
Okay, so after the latent prints were developed, I go around, people tell me where they found prints, and I will go around with a magnifying glass, pick out the prints with the best detail, mark them and label them in a similar manner, then notify the photographers as to their locations so they can be properly photographed prior to collection.
And picture 6, please.
That is off of a exterior door handle. And if I could refer to my report, I can get you the correct door.
If you can, thank you.
Okay, that's the same set of French doors that we took prints off of in the previous photograph. And this is one of the exterior handles. And you can see the latent print here. I remember developing this, and then I went ahead and marked it as exhibit 80, latent print number 6.
Thank you, sir. You could have a seat. Now, I asked you previously about the Chevy Suburban. If you can, just briefly, and did you have an opportunity to process the Chevy Suburban at a later date?
Yes,
What day was that?
it was the 28th of May in 2019.
Where were you located?
At the New Canaan Police Department, the vehicle was located in their Sally Port.
And who was with you during that processing?
It was Sergeant Joe Duva was our supervisor. It's myself, Detective Gavin, I believe Detective Pearson, Detective Keppel.
And if I can, sir, I'm going to draw your attention just to take a look behind you. This is under States 9, File 14. Picture 1. Do you recognize that, sir?
Yes, that's the Chevy Suburban prior to our start of processing.
Picture 2.
That's the rear of the Chevy Suburban.
Picture 3.
That's a view of one of the running boards of the Chevy Suburban.
And if I can scroll in a little bit. Sir, what is depicted in the white marker and the, I guess, pink arrow as well?
Right, so that's a blood-like stain we found just above one of the running boards. It was designated, tested, and swabbed and collected in the same manner as we did in the house.
And with respect to the results?
The test results were positive.
And the swabbing, did you conduct that in the same process as you did the 2 swabs? And
Yes, 2
every-
swabs, same collection.
Now, were you wearing gloves and protective gear in the course of processing the vehicle?
Yes, just gloves.
By the way, what was your assignment with respect to May 28th processing the vehicle?
I still maintained a position of evidence collection officer for this.
Picture 5, sir.
That is a blood-like stain pattern found on the lower edge of one of the doors.
And picture 6.
That's a sample from the stain pattern. I tested, collected as State Police Exhibit 106. The arrow denotes the stains that I took.
The stains that you took for what?
Oh, I'm sorry, that I swabbed and collected as evidence.
State 7.
Again, those are additional stain patterns found on the door of the Suburban.
And States 8.
And that's another blood-like stain pattern.
And same questions, same.
It was tested, collected, and marked in a similar fashion, collected with the 2 swabs.
States 9.
That's the blood-like stain that I first saw on the bumper on Lapham Road. And again, I tested it, collected it, and marked it as State Police Exhibit 105, and the test results were positive.
States 10.
That is blood-like stains that were found on the steering wheel of the Chevy Suburban.
And same question, sir. Did you?
Same collection method. It was tested, test results were positive. It was swabbed and collected as State Police Exhibit 118.
Were there also any swabbings done further of the inside of the vehicle?
Yes.
Where?
I do believe we did DNA swabs of the various parts of inside of the vehicle in an attempt to collect DNA. So we choose these areas based upon the areas that people touch when they're driving. So the insides of doors, steering wheels, top and bottom, gear shift, areas such as that.
States 11. What does that depict, sir?
That's the rear cargo area of the Chevy Suburban. The adhesive scales in the pink arrows denote areas where blood-like staining was found.
Specifically, I'm going to ask you about states 12. What is that?
That is an area of blood-like staining. It's hard to see with the dark carpet. And that was found in the rear cargo area. It was tested, collected and seized in the same manner as all the other swabbings of blood-like stains. It was denoted as State Police Exhibit 121.
And the test results?
Test results were positive.
Oh, one more, sir. What is that?
That's a blood-like stain found on, I believe it's the driver's side wall of the rear cargo area. This also field tested positive for blood and was swabbed and collected as exhibit, State Police Exhibit 120.
Your Honor, with respect to the next few photographs the state intends to introduce, I know the court's ruling previously, but if I would, perhaps now would be a time to excuse the jury for a few minutes, or the state can go into it.
Well, the court would not expect 10 minutes worth of argument.
No, sir.
So, ladies and gentlemen, we will excuse you for a brief period. There will be some discussion of the next exhibit. And so we ask that you retire to the deliberation room and please do not discuss the case. Yeah, please be seated. Thank you. Would you put those up on the screen, please?
Sure, Your Honor. If I may, I believe it is. This would be picture 14, picture 15, and picture 16.
Thank you. Easiest way for the court to probably do this is just a brief offer of proof as to how these exhibits are going to be explained.
If I may, Your Honor, may I just
Yes.
inquire of Detective
Yes.
Riley? Thank you. Detective Riley, I'm going to have you draw your attention to photograph 14 behind you. What does that depict, please?
That's a photo of the rear cargo area. It's a time exposure. So the photo's taken over a longer period of time after the application of a chemical called luminol.
Okay, a couple questions about what you just said, okay? With respect to the content of the photograph, you said rear cargo area, is that of the Chevy Suburban?
Correct.
Okay, now with the, were you present when this happened?
Yes.
Okay, you used the word luminol, what does that mean?
It's a chemical that we use to detect latent blood, that is blood that's not readily seen. We use it as a search tool. It's not we don't use it as a presumptive. We use it to search for blood that's not readily visible. If we find stains of or areas of interest with the luminol, we'll go ahead, conduct further observations. We utilize the KM test, and if the KM test is positive, then we'll take evidentiary samples from those areas.
And with respect to luminol, does that give it any presumptive, wait, you said luminol for blood that's not readily available. How does that work? Or readily seen, I guess is the way you said it.
Correct. Yeah, the blood, we use it to search for latent blood. So the luminol reacts, it glows blue due to the iron present in blood. However, it reacts with substances that contain iron, along with several other different substances. What we do is once we mix up a batch of luminol that we're going to use on scene, we'll apply it to our known blood sources, the horse blood, the pig blood, and see how that reacts, and then we'll use it on an area of interest and see if we see any similar reaction.
So is it really the detection of iron? Is that what luminol is looking for?
Well, that's what luminol reacts to in blood.
Okay. And with respect to the fact, well, strike that if I can. You said you mix it up on scene.
Yes.
Walk me through that process.
So we get our luminol from a forensic supply house. It comes with a solvent, a bottle of solvent, and the luminol comes in powder form. We follow the instructions, we mix them together, we attach a spray head, and then we'll apply it to a surface.
Is this something that you're trained in?
Yes. I remember one class where we did use luminol.
And is this a tool that you have utilized in the course of your career at the Connecticut State Police?
Yes.
About how often?
Not a lot. I would say I've probably applied luminol 15 to 20 times.
And with respect to the photograph exposure process, how does that work?
So we'll set a camera up on a tripod so it's steady. We'll put the camera settings to keep the shutter of the camera open for a longer period of time. And then we'll apply the luminol, and if there's a reaction, we'll open the shutter, the camera will do its thing, and once the photograph's complete, we'll move to a different area.
Is there a lighting on anywhere around?
Yeah, I apologize. So luminol has to be used in a darkened room. The bluish glow is very faint if we have a reaction. So in this case, we close the sally port door. If there were windows on it, I don't remember if there were, they would be papered over. So we basically work in the dark with flashlights.
If I may have one moment. That would be the state's offer, essentially.
May I briefly cross?
Well, this is just essentially an offer of proof.
Yes.
So this is how the court understands the offer. Luminol detects blood that cannot be seen with the naked eye. However, it detects, and the court is not certain that this was the testimony, it detects any substance that contained iron. That includes blood. After that, there's further testing. After that, there may be the swabbing and the collection and essentially the KM test. That's how the court understands the testimony. The photos that are viewed at this time are time-lapse photos. In other words, this isn't a snapshot, as the court understands it. The time-lapse photo. The blue as it appears on the screen, as the court understands it, is bluer than what would be seen typically, because the testimony and the offer was that the blue is very faint. Here on the screen, the blue is not very faint. So during this offer, the court will ask you, detective, is the color of the blue on the photograph darker than the blue that would appear after the application of luminol?
That's what a positive reaction looks like, Your Honor.
So you would describe that as faint?
It's faint where if it was in natural daylight, you wouldn't be able to see it.
Oh, but because it's against the backdrop of essentially a dark backdrop, it looks more vivid than it would look.
No, that's fair, Your Honor.
Well, the defense is concerned, Attorney Schoenhorn, you may indicate.
Yeah, very briefly, the latter comment by Your Honor, this isn't how it would appear even in in the detective's visual appearance of the back of the vehicle. But my bigger concern is there wasn't, this luminol is not a detection for blood, it's a detection for iron. This is the back of the vehicle. It detects steel, iron. I understand it also can detect copper. It also can detect any vegetables or that have iron, such as turnips and horseradish, those kind of root vegetables, and a number of any other kind of food that might contain like meats and whatnot, or hamburger if a child was eating a hamburger in the back or it spilled a little bit in the back. So more so my concern than more so even than the concern I have about the Kastle-Meyer test, where there's an observation, it was a test was performed, a presumptive test, and then it was passed on. Here, there was no confirmatory test whatsoever. Therefore, and when the DNA from these areas was later tested, there was no DNA that was determined to conform to the DNA of Jennifer Dula. So in addition to the concern I have about it being misleading, the additional concern I have is that in light of what is going to happen later, there is no relevance to it whatsoever. And I'll just note as an aside, my other concern is that the court allowed in the Kastle-Meyer multiple times, suggesting that, well, I can take care of that in cross-examination. My concern, Judge, is that's shifting the burden to the defense to go over each and every time there was a claimed presumptive test, when it's going to determine that many of them turned out to be negative when they were tested at the lab. But my concern here is different, at least in the other, my other objection. There was, at least as I understand it, the court said there was a visible item that was being tested, and that was why the witness did what he did. Anything else here, he's already testified up until this point that there were items he swiped. He can simply testify that he did take additional samples in the back without getting into what luminol is, what it does, and since it doesn't test for blood, it tests, and I left out bleach as another substance that glows when luminol is applied. I don't know how that's going to, I don't even know if the state would then not put on evidence of the what was done in the back of the car, and therefore that leads to the defense having to call laboratory people to say, no, it was negative. It leaves a false impression that this was in fact somehow blood, when I think the court is correct it only tests for things that have iron in them. And I would know copper is not iron, but it also tests for copper. But in a motor vehicle, all of those things, especially in the cargo compartment, would likely be found. And I'll just incorporate my prior arguments so I don't have to repeat anything.
Well,
If I can just clarify.
The court can address this right now. The, again, issue of false impression, essentially giving life to what may be considered to be misleading, is not evident here. Not only is the luminol application far from conclusive, it is not even at the level of presumptive. It detects many more things than blood. It detects iron. Then there's further testing to get it up to the point of even being presumptive. So the court sees no danger for unfair prejudice or misleading evidence. The court is going to allow the evidence.
Could the court at least, what I'm not understanding, I'm not understanding Your Honor's ruling, because what the court said is it has essentially no evidentiary value, and then the court rules that it's admissible. Could the court at least articulate how it gets to that position? I'm just trying to understand down the road, since we're going to be having this happen more often than you think.
The court did not say it has no probative value. Relevant evidence is evidence that has any tendency to make a material fact more likely or less likely than it would be without the evidence. The court did not say it has no probative value. The state has the opportunity to present the case the way the state wishes to present the case. If it wishes to present evidence of luminol and latent blood that falls below a presumptive finding, that's the state's determination.
I'll just ask the court to note my strong exception, since I'll just remind the court that State versus Moody said that luminol has no probative value. So the fact that the court says it does, I don't know where to go with that other than to just enter my strong objection.
You can bring the jury back.
Just prior to the jury coming out, Your Honor, those 3 photographs are still ID only. May I just inquire, are they moved to be full exhibit at this time?
Would counsel stipulate to the presence of all of the jurors?
Yes, Your Honor.
Thank you. Do you wish to make your offer of those exhibits?
Yes, Your Honor, I would. This would be States 9, file 14. The offer involves photographs 14, 15, and 16.
Objection, Attorney Schornhorn.
I stated my objection.
Thank you. Overruled. Which numbers are they, please?
They are States 9, file 14, numbered photographs 14, 15, and 16.
States 9, file 14, photographs 14, 15, and 16 admitted as full exhibit.
Thank you. So if I can, I'm going to draw your attention here. States 13, if you can take a look at it. Sorry, is that, where is that located in the Chevy Suburban?
That area is in the rear cargo compartment of the Chevy Suburban that would be on the driver's side.
With respect to the rear cargo area of the Chevy Suburban, did you do anything to, in the course of processing the car with respect to that area?
Yes.
What did you do?
So we conducted a search for not only visible flood-like stains, but latent flood-like stains.
What do you mean by latent?
Latent just means that you can't see it. It needs something to be developed.
And what did you do to develop that?
So we utilized a chemical called luminol that we get from a chemical supply house. It's a liquid that you spray onto a surface in a darkened environment, and it will react with the iron contained in blood and glow a faint blue.
And with respect to reacting with the iron in blood, does it react to other things as well?
It reacts with a lot of different things.
Can you name a few, please?
So it reacts with iron or anything with iron in it. It'll react with bleach. So it's a limited use in like a bathroom. And it'll also react with some foods as well. There's a laundry list. We utilize it as a search tool. We have to do further presumptive tests, and then of course, any samples that we collect, we have to send to a laboratory for confirmatory tests.
And just for the record, the photograph 13 behind you, was that KM tested as well?
That exhibit was KM tested.
Okay. And seized as exhibit, what exhibit number did you see?
State Police Exhibit 120.
And with respect to the pink arrow, what does that depict?
That's the area where I took those evidentiary swabs from.
Now I'm going to show you what's been marked as states 14. What does that depict, sir?
That is a time exposure of our application of luminol.
Of well.
Oh, I'm sorry.
Of
This
what?
Is, sorry. This is the rear cargo area of the Chevy Suburban. While it was still parked in the Sally Port, we closed the doors. We make it a darkened environment, and we sprayed luminol throughout the rear cargo area. It took several time exposures.
Where do you get the luminol from?
We get it from a forensic supply house.
And how do you, I guess, apply the luminol?
So it comes, the kit that we get from the chemical supply house comes with a bottle of solvent, and then luminol comes in powder form. We mix those two together. We attach a spray head, and then we do a test on our known blood samples, or either pig blood or horse blood, and see what kind of reaction we get. Then we will apply it to an area of interest and see if we get any reactions. If we get reactions, we'll go ahead and test those areas with the Kasselmeyer test, and then determine whether or not we want to take evidentiary samples.
And did you do that in this case?
Yes.
Okay. How did you take a photograph?
The photograph is a time exposure. So basically we put the camera on a tripod and either set the automatic settings or set shutter settings. So the shutter stays open on the camera for a longer period of time. Since it's a darkened environment, it takes that amount of time to take in enough light to make a photograph.
And were you, well, I'm going to show you behind you states 15. What does that depict, sir?
That was taken during our luminol examination. That's, again, the rear cargo area of the Chevy Suburban. I believe that's more focused on the driver's side of the vehicle.
And states 16. What does that depict, sir?
Again, taken during the luminol examination. And that's the passenger side of the rear cargo area.
Did you have an opportunity to examine the Chevy Suburban at a later date?
Yes,
When was that?
June the 26th of 2019.
And what was the purpose of that?
The purpose of that was to try and search for additional biologic material to aid the medical examiner's cause and manner investigation.
Did you look at a specific area of the vehicle?
The undercarriage specifically.
And by undercarriage, what do you mean?
The underside of the car.
File 16, show you picture 17. Do you recognize that?
Yes.
What is that?
That is the Chevy Suburban, Jennifer Doulos' Chevy Suburban.
Where is the location of this? Where was the location of this processing?
This was processed at Troop G Bridgeport.
Picture 18. What does that depict, sir?
That is the passenger side of the Chevy Suburban. You can see the black metal of the door on the upper part of the photograph.
If you wouldn't mind, again, sir, if you can get up and point to the photograph, please.
So you have the vehicle here, and here is the undercarriage. This is the underside of step bumper, frame rail. And this is some blow-like material we found on the edge of the undercarriage.
The word written on the white side, what does that mean?
So that was placed there by the photographer to designate which direction is the front of the vehicle, because you know, the photographs can get a little confusing.
Picture 19, what is that?
Okay, this is an item of interest that we found during examination of the undercarriage. Again, this is on the passenger side. We're looking at this this clearish little specimen right there. So, and we designated this as item A. Our collection process for this is I've removed this with a sterile scalpel, packaged it in a little paper fold, and later the next day transported it to the medical examiner's office so he can do he can put it underneath the microscope and see you know, what kind of cells are there. In the same area, after this was removed, I went ahead and swabbed the area with sterile water, same manner, with 2 swabs.
And photograph 20, please.
Item B, I believe it's on the frame rail. So you can see the exhaust here, bolts for the running board. And so I'm looking at this little fleck of material right there. Again, this was collected in a similar manner.
Picture 21.
Item C is on the running board. This area here. You can see it's a little heavier of a stain. There's a little, it appears to be like a little yellow to it. It's different than, you know, there's more there than just typical blood-like staining, so that's why it was an item of interest. Again, this is collected in a similar manner, scraped off into a paper fold, and then the area was swabbed afterwards.
Picture 22, please.
This is a photo of what would look to us to be a footwear impression on the inside one of the wheels of the Chevy Suburban. And I believe this was taken on the 28th of May during our vehicle processing.
Picture 23.
Again, we printed the exterior of the vehicle. And
I believe we took a swab from here, but I'm not really sure.
Would it refresh your recollection to take a look at your exhibit report?
Yes.
May I approach the clerk again? So I'm going to show you what's been marked as ID states 12. If you can, just take a look and please don't read from it. Let me know when you're done. Did that refresh your recollection, sir,
Yes.
as to if there was a swap done of that photo, what's depicted in that photograph?
Yeah, so this is the exterior side of the vehicle's tailgate. This is the bottom edge right here. And during our examination of, you can see the application of fingerprint powders. All right, so there's not a lot of, there's absolutely no ridge detail here whatsoever. However, it was handled, so we swabbed it. I took 2 swabs that were moistened with sterile water, swabbed this area, and then collected it and designated it as State Police Exhibit 113.
In picture 24, sir.
This was taken during a latent print exam of the exterior of the vehicle. Again, we're running sequentially with latent print numbers, so this is latent print 11, State Police Exhibit 114. And again, I designated it with blue China mark, arrow for orientation.
And picture 25.
It's appears to us to be like a partial palm print. Found on, not sure where exactly this was on the Suburban.
Would it refresh your recollection to give me a look at your report?
Yes.
And just for the record, I'm almost done with this section. And one more question after this.
Well, it's the answer, the length of the answer that concerns me. So the court is going to conclude for the lunch recess after this photograph.
Thank you.
This is this was developed on the rear edge of the right front door. So, kind of near the window, okay? And so, again, designated as latent print number 12, exhibit 115, marked and lifted in the same manner.
Thank you.
Okay, thank you. Ladies and gentlemen, we approach our lunch and recess. We plan to resume at 2 o'clock. Please do not discuss the case. Thank you.
All rise. This honorable Superior Court now stands in recess until 2.
Thank you.
Hill, gear shift, I believe seat adjustment controls, things like that.
And do you recall what exhibit number those were?
Not off the top of my head, ma'am.
I may just have one moment. Don't have the box up there. Never mind. I may just have one moment, Your Honor. No, it's not. I'll withdraw that, Your Honor. I don't have my file for that one. May I just have a moment?
Yes.
Okay, so with respect to the other vehicle that was inside the garage, the Range Rover, I'm gonna draw your attention specifically to States 9, file 15. If you can, take a look behind you, sir. What does that vehicle depict, please? Or, I'm sorry, what does that picture depict?
That's the front of the Range Rover that was parked in the garage at 69 Wells.
Picture 2, what does that show?
That is the driver's side of the Range Rover.
And I'm gonna draw your attention actually down to and scroll in to the here where there's a pink sticky and a marking. It's a little blurry, but can you see what that depicts, Sheriff?
I can't see, ma'am, but it's marked up in a similar manner of a swab being taken.
Do you recall what swabbing that was?
Can I take a closer look at the screen?
Yes, and would it also refresh your recollection and take a look at your report?
That would be better.
If I may just approach the clerk, Your Honor.
Yes.
Okay. 11 for ID.
Thank you.
Thank you. Did that refresh your recollection, sir?
Yes.
If you could, if you wouldn't mind, getting up and pointing to the screen again, I apologize. And could you please identify, if you could, to your knowledge and recollection, what markings those are?
Yes, that is Exhibit 61 is on the front door. And 62 is on the rear door.
And with respect to those exhibits, did you swab them?
Yes, they were field tested, swabbed and collected in the same manner as the other stains in the garage.
And was that 2 swabs?
2 swabs for the evidentiary collection.
And CAM, the result?
CAM was positive.
State picture 3. What is that, sir?
That is another blood-like stain found on the Range Rover. As far as location, I would have to refer to my report.
If you could, sir, please. And do you know the location of that photograph or what's depicted in that photograph?
Yes, that was a blood-like stain we found on the left side of the hood.
Was that swabbed?
Yes, it was field tested, swabbed and collected.
And the results of the field test?
Field test was positive.
So picture 4 out of file 15, I believe. What does that picture depict, sir?
So that's the Exhibit 61 I spoke about before on the front door of the, left front door of the Range Rover. And you can see the apparent spatter pattern that the stain was collected out of.
And same questions with respect to the seizing of it as an exhibit, please.
Yeah, so that was field tested. It was field tested positive, and then it was collected in the usual manner.
And that's 2 swabbings?
2 swabbings, correct.
Thank you. Picture 5.
That's a blood-like stain found on the left rear door of the Range Rover. And that was field tested. It was KM positive, and it was collected with 2 swabs, similar to all the others.
And when you say rear door, which side of the vehicle?
That was driver's side, left side.
Picture 6.
Picture 6 is the left front corner of the bumper of the Range Rover. State Police Exhibit 60 was a swabbing, or 2 swabbings collected from that stain that the arrow was pointing to. And Exhibit 69 is a sample of the blood-like stain that was found below it. Both items were field tested. They field tested positive, and both were collected in the usual manner, 2 swabs.
Picture 7.
That is a photo of State Police Exhibit 63. The location of which escapes me, ma'am. I
If you
can
could
refer to my
refer to
report.
your exhibit report, please. Which for the record, it states 11 Friday.
Okay, that stain is on the left rear fender of the Range Rover. It was also field tested positive with the KM test and was collected with 2 swabs in the usual manner.
Picture 8.
Okay, so 8 is a latent print taken from the Range Rover. Latent print number 9, Exhibit 93. If I could double check the location.
If you could refer to your report, please.
And latent print number 9 was lifted from the front fender.
And just with respect to the latent print number 9, can you just walk us through the process of taking the print off of the vehicle?
So this print, again, once it was developed and marked, photographed, we would take adhesive acetate, something clear. Probably in this case, I used a gelatin lifter. Again, it's a thin layer of gelatin on top of a rubber backing. It kind of molds better to the curves of the car.
Picture 9.
That is a photo of Exhibit 58, which was a sampling of the blood-like stains found on the grill.
And if you could just head up to the screen, I have a few questions with this. Now, with respect to Exhibit 58, what did you designate 58 as?
It was these blood-like stains here.
And did you do any testing or anything on those stains?
I field tested these with the KM test, which was a positive test.
Okay. Actually, if you could, what about up here, one above, I'll start with the one above the V.
I believe those scales were placed there to document the apparent spatter found up here, probably placed there by the photographers.
Did you take any samples or swabbings, I should say, for anything above the rover, the words
No,
rover?
because they're not marked as an exhibit.
Picture 10. So with respect to the, right above the, I guess, the measurement marking or the label, the Exhibit 58, was that the area that was swabbed? Or that you're designated as Exhibit 58, or is it, my other question is it above the grill? Is it separated, or did you include that as the entire, any of the blood spatter?
I'm sorry, can I refer to my exhibit report?
If you can.
Okay, I was mistaken. This wasn't a blood swab. We were treating this this apparent impression or print and blood-like material that we found on the grill. We photographed this in the usual manner, in a manner similar to the way we did the prints on the floor. So these were photographed, and then later the photographs were designated as Exhibit 58.
So just to be clear, there was not swabbed in this?
I did not swab this.
Okay, and it was not tested or it was tested?
I believe.
Objection.
I'm just asking to
Well,
clarify, Your Honor.
The question is, was this swabbed or was it not swabbed? And the response was going to be, I believe. Well, there can be a follow-up question. Court will overrule the objection.
I can't say for sure.
And with respect to any testing on it, do you recall if there was any testing on Exhibit 58?
Nothing beyond photography.
We on to photograph 11. What does this depict?
That is more blood-like stains on the grill of the Range Rover.
And picture 12.
That is another photo of the blood-like stains on the left rear door of the Range Rover.
And what about this marking from, I guess, in the middle
And
of
so, along the side of the car, you can see in this road grime here, salt, dirt, sand. You can kind of see it like a swipe mark through there.
picture 13?
Photo of some blood-like stains on this is the left front wheel of the Range Rover.
Now, with respect to the Range Rover, was there also a additional processing?
Yes, we process this in our usual manner of processing a vehicle.
And I'm going to show you what's marked.
Before we proceed, Attorney Manning, it may be more advantageous for the record if there was a better description of wheel.
Oh.
Is it tire? Is it rim?
That's true. Thank you, Your Honor. Sir, if you could just describe what you see in the photograph, please. This is states 13.
Sure. When I refer to the wheel, it's really the rim, not the rubber tire. So I'm looking at these, I'm referring to these blood-like stains inside the metal of the rim.
And for the record, you're pointing to where on the photograph?
Basically throughout in the approximate center of the photo.
And picture 14, sir, do you recognize that?
Yes.
What is that?
That's the Range Rover. We examined this along with the Chevy Suburban at Troop G in Bridgeport on June the 26th, 2019. For similar material, additional biological material from the undercarriage.
Picture 15. What does that picture depict?
This is an overall view of the undercarriage seen while the vehicle was up on the lift. You can see on this L-shaped scale here, the photographer added a directional arrow for front. So the front would be the top of the screen. And then driver's side or left side of the vehicle is toward the right side of the screen.
Picture 16.
This was seized from the lower area of the Range Rover as item D. Again, this was scraped into a paper fold, designated as item D, and later the area was swapped.
And item E. I'm sorry. Picture 17, with respect to item E on picture 17.
Yes, this is on the left side of the Range Rover. Again, kind of around the rocker panel. So item E is designated by the arrow. This material was scraped into a paper fold, and later the area was swabbed.
And picture 18, please.
Again, just another photo of item E.
Thank you, sir. You can sit down. I want to go back and ask you a few more questions about that October processing of the Chevy Suburban. Do you recall how many exhibits you took, if any, out of the car that day?
Not off the top of my head now.
If I can. Would it refresh your recollection as you go to your report?
Yes.
And may I approach the clerk, Your Honor?
Yes.
So I'm going to show you what's been marked as 13 for ID. Please take a minute and take a look at it. Please don't read it out loud.
Okay, ma'am.
Okay. Did that refresh your recollection, sir?
Yes.
Okay. With respect to that processing, how many swabs were taken out of the car that day?
There were 6 exhibits containing anywhere between 2 and 4 swabs.
And what were some of the, for instance, do you recall exhibit 370?
Yes.
What was that swabbing of?
That was a swabbing of the steering wheel, and that was complete with 4 swabs.
And are you utilizing a report to refresh your recollection on this?
Yes.
Okay. Exhibit 371?
371, again, 4 swabbings from the steering wheel. These were from the areas with visible blood stains. The item before that, 370, was taken from unstained areas or apparent unstained areas.
Attorney Manning, the court heard that there was a third processing in September 2019, and counsel made reference to a processing in October.
If I may inquire of Detective Riley, Your Honor, is there another processing in September?
No, the processing where we took the extra swabs was actually, the proper date was October 18th.
Thank you.
I apologize.
And with respect to how about exhibit 372?
372 was 4 swabs taken from the interior side of the left front door.
Do you recall where that was on the door?
It was, I ran the swabs around all areas of the door in an effort to pick up as much genetic material as I could.
And exhibit 373?
That was taken from the left front seat adjustments. This was 2 swabs.
And by front seat adjustments, just what do you mean by that?
So they're the side buttons on the driver's seat used to adjust the seat for the driver.
And 374?
374 was swabs taken from the rear view mirror.
And 375?
And 375 was swabs taken from the rear seat controls in the cargo area.
If I may have one moment, Your Honor.
Yes.
I have nothing further, thank you.
Cross-examination, Attorney Shaw.
Good afternoon, Mr. Riley. You're retired, right?
Yes,
I hope you're enjoying your retirement.
I am, thank you.
Let me ask you a few questions. Let's start with this presumptive testing that we've talked a lot about here. It's my understanding, as you testified, that when we're talking about these chemical presumptive tests, there are at least 2 that you talked about today, right?
Yes,
The first was called Castle-Meyer, begins with a K instead of a C, right? It's like hyphenated, 2 names.
yes,
And the second one was something called luminol, right?
yes,
And Castle-Meyer, you said, is made up of 2 chemicals. One is phenolphthalein, right?
yes,
And the other is hydrogen peroxide, right?
yes.
Now, phenolphthalein is the stuff that they use to test swimming pools for chlorine, right? Isn't that the same stuff?
I don't know, sir.
So you're not an expert in science. You're not a chemist or anything like that, right?
No,
So when you said you had some training in it, you were trained in how to administer it, right?
yes,
You don't know anything about the chemistry itself and why something shows pink or glows or changes color at all, right?
that's correct.
And the training, you said you also received from the lab some kind of like a kit in order to administer it, right?
Yes,
And phenolphthalein is a liquid, isn't it?
yes,
And so is hydrogen peroxide, correct?
yes,
Now, hydrogen peroxide, that's the same chemical that you use maybe if you have an infection, maybe to disinfect, right?
yes,
And I guess some people might even use it to bleach their hair, right? In the day, right? Isn't there people have peroxide hair where they really white bleach blonde? Is that the same stuff?
I'm not sure, sir.
Okay. But in any event, you also said that there are things, when you talk about presumptions, right? You're trying to see if there's a place that you're going to do some swabbing or photography, right?
For the Castle-Meyer,
Yeah.
it's more, we do our searches visually.
Okay, so you see something that looks like a stain, right? You maybe do a little chemical wipe with the KM, right?
Or conduct the KM test, correct?
You do a KM test, and if it comes back negative, do you still take a picture of it?
Sometimes,
So we saw a couple of those. You tested a stain on the floor of the garage, and it didn't even come up with a presumptive test, right?
right,
But in any event, if it comes up presumptive, one of the things you indicated that it's presumptive for is blood, right?
Well, the test, it's presumptive for blood.
That's what I mean. The test is presumptive for blood by putting the two chemicals together with the sample, right?
Yes.
And you did mention a couple of things that it also is presumptive for, right?
Yes.
Animal blood is one.
Yes.
And of course, there's all sorts of animals, right?
Yes.
Doesn't distinguish between one animal or another, does it?
No.
I think you also mentioned horseradish is something that it tests positive for.
That's one of the classical examples.
Okay. Now, are you familiar with some of the other things that it tests positive for?
I'm familiar with turmeric.
Turmeric, right? Now, doesn't it also test positive for tomato?
I don't know.
What about rust, iron rust?
I don't know.
You don't know?
No.
How about bleach? You know about that?
No.
How about copper?
No.
You don't know? Is that what you're saying? Whether it'll show a presumptive positive for copper? Like iodized copper?
I don't think so, sir.
How about malt, like you find in either beer or a milkshake?
That I don't know either.
Aren't there, in fact, 16 different food groups that test positive using Castlemaine?
I don't know, sir.
We'd have to have somebody who's like a scientist that knows this to really answer those questions, right?
Yes.
But if we're talking about a presumptive test, if you wanted to be presumptive about the presence of horseradish, this would be the test to use, right?
I would need to presume something was horseradish, sir.
Well, the presumptive test is not what you think, it's whether it turns pink, right?
Yeah, I'm not sure I'm following your question, sir. I mean, it does react in a positive manner with horseradish.
So I'm saying if I wanted to presume that a stain on my kitchen cabinet is horseradish, I might use this test, right?
If you really wanted to.
Exactly. And so let's say a, I don't know, spilled piece of hamburger juice, that would test positive, right?
I don't know. I've never tried it on hamburger, sir.
Well, hamburger is basically animal meat, right?
Yeah, but I've never tried it on hamburgers.
Fair enough. But it would also test positive for, I don't know, a cat, little blood from a cat, right?
Oh, yes, animals, absolutely.
Mice, right? There's a garage, right?
If you had an injured mouse, yes.
But you would also agree, would you not, that you would need a confirmatory test done by a lab to see whether the presumption or assumption turned out to be correct, right?
Yes.
And you know that in your, never mind this case, but in your experience, some of the things that you show a positive presumptive test turn out not to be blood at all, correct?
I've never had that experience.
Well, you don't do the actual testing, do you?
No, I mean, when I learn of the
I'm
results,
still here, guys.
I've never had that experience.
So you don't know that in this case, that was in fact, several of these items turned out not to have any
That's why.
evidence of blood in it?
Objection, Your Honor.
Staying.
You didn't even test all of the spots then for this one.
Me personally, no,
Yeah.
I didn't.
This is a YouTuber.
Let me ask you a few questions about luminol. There's some pictures in the back of the Suburban, right? Including a couple in the dark where you see this little purple glow, right?
Blue glow, correct, sir.
Blue, purple. Those were kind of like, those photographs were taken with a time-lapse
I'm
photography,
still
right?
here.
Yes.
They appeared brighter than they might with the naked eye, right?
I can't say for sure, sir.
And you use that in order just to choose where you might take another spot, right?
Yes.
Now, you said that luminol tests for the presence of iron, right?
Yes.
So you know that a car is made out of steel, or most of them are, right?
Yes, it is.
And steel is an iron alloy, is it not?
It is.
So it would stand to reason that in a motor vehicle, there might be some exposed metal places that might test positive using luminol, right?
Correct.
So if you wanted to see if your car was rusty, you might spray some luminol on it, and you would have a positive glowing result, right?
It would even glow on the non-rusted parts.
Right, but it would glow on even the non-rusted parts because you're in a car, right?
Yes.
And if you're talking about, let's say, a car where there are children that have been passengers in that car, there might be all sorts of other things that will test positive for the presence of iron. Isn't that true?
Possibly, yes.
You know that I think turnips also test positive for luminol, don't they?
I don't know that for a fact.
You know, a lot of root vegetables have iron in them, right?
No.
You do know that.
I do
right?
know.
And it's actually they're good for you to eat, right? Am I right?
I'm gonna object, Your Honor.
Well, the question's not relevant, sustained.
You wanted to see if you maybe dropped a turnip on the ground in the back seat of the car, you might use luminol and it might glow, right?
Objection,
Brown.
irrelevance, and I assume it's facts, not in evidence.
Well, the line of the cross-examination is a number of substances or fruits or vegetables contain iron. This is just an extension of that line overruled.
All right.
I think you'd be able to see a turnip and would need luminol.
But the luminol might illuminate it, right?
I don't know. I've never tried it on
Never
a turnip, sir.
Fair enough. Bleach also will glow in luminol, won't it?
Yes.
You already mentioned horseradish for K&M. This would also test positive in luminol, wouldn't it?
I don't know for sure.
How about rust?
Yes.
So if a child had, let's say, ice skates in the back of the car, some of that maybe scratched off on the back seat,
Objection.
that would test positive for luminol, wouldn't it?
Well, here's an objection. And it calls for a hypothetical, but the hypothetical isn't developed in such a way as to aid the jury. Essentially what the question is since there are ice skates have metal, probably steel. Steel is an alloy of iron. In other words, it's an extension, but the extension is becoming very thin. But the court is going to allow the question.
And I will then move on, but if you want to just answer that question, I'm not going to go into a million hypotheticals.
Yes, it's possible.
All right. A lot of these photographs that we've seen were various angles of the very same spots that you tested, isn't that right?
Yes.
So just by looking at these photographs, you'd have to look very carefully to see whether or not 3, 4, or maybe even 5 photographs were of the same location that you did a swab. Isn't that right?
No, I just swabbed from the areas that were marked as exhibits.
Oh, no, I understand that. I'm talking about photographs from different angles to a certain extent of the same areas that you had swabbed.
Yes.
I also want to be clear about the measuring tapes that are in many of these pictures. The white tape is in centimeters and millimeters, correct?
And I believe it's inches on one side too.
Well, the yellow, isn't the yellow the inches?
You said the white tape, sir?
Yeah, doesn't the white tape say metric on some of them in those pictures?
I don't know. I would have to look at the pictures.
All right, fair enough. But if you're familiar with the fact that there's a distinction between the metric system, which uses centimeters and millimeters, and the American measuring system that uses inches and feet, right?
Yes.
I want to ask you a few questions about the paper towels in the kitchen. And the first thing I want to do is call up one of the pictures that was on the exhibit that was introduced through you. And if I could have 8-139. For your edification, this is the image where you put the the state police exhibit number 13. If you would look at that screen behind you, sir, you see that image there?
Yes.
And I think you testified that this was the paper towel that you examined. You did some kind of a test on it as well, right?
Yes.
And you seized the whole thing or just a portion of it?
The whole thing, sir.
When you came into the house that day, this would be the 25th, correct?
Yes.
Was this exactly when you went in the location where you found this paper towel roll?
Not the exact location, no.
It was moved around?
It was in that general same corner of the sink, sir.
Did you move it so that somebody could take a better picture?
No, I moved it so I could examine it and field test it.
When this picture was taken and you put that yellow tab next to it, is that the location you found it in before you moved it and examined?
No, I don't believe so, sir. Not the
Where
same
was
as
it when you first observed it, if you can just point it out on this photograph?
I would just remember in that general corner of the sink, sir.
So when you say in the corner of the sink, was it off the roller? That is the metal device that the paper towel roll is standing next to?
I believe so, but I'm not sure, sir.
Did you observe anyone else move it? Take it off?
No.
And just so that we're talking about the same thing, right? I'm referring to this item here that's to the left of the paper towel roll. You see that there?
Yes.
You recall seeing that there, right?
Yes.
But when you got there, that paper towel roll was not on that device, the dispenser roll.
I think they were separate, but I'm not sure.
Well, if you're not sure, do you not recall seeing someone physically remove it?
Objection.
Well, the response was he's not sure if it was on the holder. And the question was, well, if you are not sure, can you recall someone seeing someone move it off of the holder?
No, I didn't see anybody move it off of the holder, sir.
So it wasn't placed there in order for you specifically to examine it in that location. Is that a fair statement?
No, I searched that area of the house, sir.
Okay. So I'm going to ask you now, I had a couple of screenshots taken from, I think it's Exhibit 7. We had Detective Clabby had a video. I took a couple of screenshots from it, and I'm just going to show you if I can.
Excuse me, may I have a moment of counsel?
Yeah.
What time is this?
Give me a second. I'm gonna have this marked if I may.
Yes.
So I'm going to show you, is there any objection to that?
That's those,
Those two?
that's this one, or this one?
Yeah, that's,
This one. Okay. No objection, thank you.
What's the marking, please?
that's exhibit A.
Fence A admitted as a full exhibit.
So if you could, before we show you the image, before you got there, you know that Detective Clabby was also on the scene, is that right?
Well, we were there at the same time, sir.
Fair enough. Did you all arrive in the van or did you come separately?
No, we came separately.
But you recall seeing him there?
Yes.
You knew that he was assigned the videography for that scene that day?
Yes.
Did you observe him doing any videography?
Yes.
Did he do that, at least the overview, before you got to work making any examples, any swabs or anything like that taken?
Yes.
All right, so I'm going to show you a couple of screenshots from that video that Detective Clabby took. And have you seen that video at any point?
Not in a long time, sir.
All right, so I'm going to show you one screenshot called screenshot. Let me just put that up, please. Now, looking at the video screenshot that I've just put up here, you see that the paper towel is on the dispenser in that image, correct?
Correct.
So my question to you, was that how it was when you observed it, or was it already off the roll when you examined it?
Objection. Asked and answered, Your Honor. He indicated he doesn't remember.
The response has been he does not remember.
All right, does that help with, all right, does looking at this image help you refresh your recollection as to whether or not it was on the dispenser when you arrived?
Objection, Your Honor.
Ground.
Again, he's been asked and answered. It's now a full exhibit.
Well,
I'll withdraw the question. I'm going to show you another screenshot in a moment, but well, it's up there now. This is from the pantry. Do you recall looking in the pantry at the in that kitchen, between the kitchen and the mudroom?
Between the mudroom and the dining room, sir?
Yes.
Yes.
All right. So if you would just put up that image, this is also from the same exhibit. You recall that this was the view of that pantry when you looked at it?
Yes, that's consistent.
Did you take any swabs or collect any evidence from what's shown in that image?
I did not.
Hi, whoever is it? Thank you for joining us. Appreciate it.
Could I have this? I would offer defense exhibit B.
No objection.
No, sir.
Defense B admitted as a full exhibit.
I'm going to show you an image that was taken from by the officer who arrived at New Canaan Police, from the New Canaan Police Department on the evening of May 24th, 2019. All right, so if we could have that. No, if you don't recognize the New Canaan police officer that's seen in this image, do you?
No.
And I'll just note the time is indicated at 5:24:19 at 19:57 and 33. This is from State's Exhibit 1, I believe, which was video that was from the body camera of one of the patrol officers that was there that night. Okay.
Okay.
So again, I'm just going to ask you to note. Did you ever see the paper towel roll on the dispenser when you were at the house?
I don't remember.
Now, I'm also going to show you two other images, I think, they're also from this exhibit. X8, please. It's image 0064 from that exhibit. Do you recall seeing any of the items that are indicated here during your investigation on May 25th, 2019, inside the home?
Specific items?
Any specific items in the pantry that were seen?
No.
I'll show you the next picture, please, which is image 0065, or I'm just calling it X21 for my, does this particular roll, did you observe this roll of paper towel in the pantry at Wells Lane when you were there collecting it?
I don't remember that.
Wow.
I'm going to show you a couple of pictures from the garage that we've already been through, and you described where you took certain swabs. The first picture I want to show you is from your disc exhibit, which I believe the whole exhibit is, I think, 7. Sorry, I'll just have a moment.
Which one? 9. No.
The large. No, the one we put in yesterday. That.
Yes.
It is 9. Okay.
9.
Sure. I'm going to show you some images from Exhibit 9, if I may. And the first exhibit I want to ask you about is marked on your Exhibit 9 is 12-362. If that, we could have that up on the screen, please. You recall this is the exhibit that you marked as A16, or somebody marked as A16, correct?
I don't think that was an exhibit. I think that was just for documentation purposes.
All right. So let me also get that clarification. If there's a yellow placard, then it was seized as some kind of an exhibit for your purposes of your investigation. Is that correct?
Or it was marked on a similar label with EX, whatever.
So the A letter, was that your writing on this document, on this image?
No.
This would be something that whichever detective was placing these markers down would have noted. Is that right?
Yes.
And I asked you this when we were first putting some of these pictures up. If we look at this image here, when you saw this particular marker, did you note the marking on the sticker itself?
No, I didn't note it.
You did not?
No.
Okay. So you don't know how that got there?
Specifically, no.
Okay. I'm going to show you another image. This one is 13-363. It's in the same series. And this is also one of the images that you testified to yesterday, correct?
Yes.
And I'm asking you specifically about the mark on the middle of this document here. Was that present when you were examining that particular spot?
Some trouble.
I don't remember it.
You don't recall seeing that?
No.
And you also testified, if I'm not mistaken, that there was also a fair amount of, you called it vegetative matter, seeds or leaves and whatnot on this garage floor, correct?
Yes.
And did you gather any of those?
No.
Show you one more in this series. This would be 14-157. Once again, I'm just going to ask you whether or not you recognize or saw this item on the placard when you were looking at this particular location of it.
I don't recall it being there.
And when you talk about other items, whatnot, seeds and whatnot on the floor, are we talking about, if we look at this picture, are we talking about all of these other specific items, dots and whatnot that we see on the cement floor in a close-up? Is that what you're talking about?
Yes,
There are also some larger leaves, correct?
larger leaves,
Well-
stones, sand, things like that.
Sand, what else?
Interesting.
Small stones.
All just on the, what you might expect to find on a garage floor.
Before you proceed, counsel, the court needs to clarify something that is quite subtle. Detective Riley, on the previous photograph, you indicated you did not remember whether you saw that spot on the measuring marker, correct?
That's what I said, yes, Your
But
Honor.
then you said, I don't recall seeing it. Now, it may sound the same, but there's subtle differences. I don't remember whether I saw it. So this court means I don't remember whether it was there or not. I don't recall seeing it means, in this court view, I don't remember that it was there. Which one is it?
It was the former. I did not take note of it, Your Honor.
Thank you.
With regard to the search of the Chevy, you said that you were sent back to take additional samples in October of 2019. Is that correct?
That's correct.
And as I understand from your testimony, it was from additional samples of the steering wheel,
Yes,
from the interior of the left front door,
yes,
from the front seat adjustment control,
yes,
from the rear view mirror,
yes,
from the cargo area,
yes.
from the rear seat controls.
Weren't those one and the same, sir?
Well, that was going to be my next question. Were those separate places, or did you take them from the rear seat controls in the cargo area because the seats were down?
Yeah, I believe what I remember, the rear seat controls were in the cargo area.
Because the back seat, the second row of seats were not up, they were down. Is that why you entered that way?
I don't remember whether they were up or down, sir.
You were sent back to do additional swabs because the first set didn't produce any information of value. Is that true?
Objection.
Well, the question is, you were sent back to take additional swabs because the first set didn't yield anything of evidentiary value. And what's the objection?
It's a mischaracterization of evidence, assumes facts not in evidence, and
Well,
and it calls for a hearsay answer, Your Honor.
let's take them one at a time. The question was, you were sent back. That's one segment. Because what you swabbed the first time did not yield anything of evidentiary value. Well, whether he was sent back or not is not material. The second segment, because what you recovered the first time was of no evidentiary value. Well, that assumes, in this court's view, facts that can be interpreted differently, but in this court's view specifically, it's misleading. Sustained.
The purpose of going back in October was an attempt to get biological material from those locations in the suburban, correct?
Yes.
And whatever you did, you made the same kind of swipe type activity that you described earlier?
Yes.
And then you sent that on to the state lab at some point, right?
I don't know if I did personally, but that's the usual process.
Right. Well, let me just, I skipped a step, all right? So you gathered it and it was then sent into evidence, right?
Yes.
And then at some point, that was done for the purpose of at some point having it examined by the state forensic laboratory, correct?
I believe so. Not sure though, sir.
Well, whether these particular items were then sent on or not, that would have been the purpose of collecting it, right?
Oh, yes, absolutely.
Just have a moment. I have no further questions, thank you.
Is there redirect?
Just a couple of questions, if I can. Detective Riley, do you recall Attorney Shohern asking you about the other items that a presumptive test could test positive for? Do you recall that line of questioning?
Yes.
Okay. I think some of the things he questioned were about radishes. Do you remember that?
Yes.
Okay. In the garage floor, did you find any evidence of radishes anywhere?
No.
Okay. What about cheeseburgers? Anywhere on the floor?
No cheeseburgers.
What about on the undercarriage of the Chevy Suburban? Did you find any cheeseburgers or radishes there?
No, ma'am.
Okay, what about the undercarriage of the Land Rover? Any cheeseburgers or radishes there?
No.
What about turmeric? Any bottles of turmeric or turmeric sources on the floor of the garage?
No, ma'am.
The Land Rover?
No.
The Chevy Suburban?
No.
All right. With respect to the cargo area of the Chevy Suburban, did you find any evidence of car seats? Any evidence that children were sitting in the trunk area?
In the back? No, ma'am.
With respect to that cargo area, did you see a lot of exposed steel in the rust areas?
No.
With
See the walk.
respect to, actually, that's all I have. Thank you.
Just a couple of questions. In any of those areas, starting at the garage, do you find evidence of rust stains?
Not that I remember, sir.
Do you notice it whether or not under the undercarriage of the vehicle there was some rust?
Yes.
No further questions.
Nothing further. Thank you.
Detective Riley, you may step in.
Thank you, Your Honor.
The time is now 3:10. You have another witness for this afternoon. do you
We
not?
do, Your Honor.
Judge, we do
Well-
have to take up a couple of matters
Correct.
in advance.
So what the court is going to do is allow the jury to take the afternoon recess now. Well, how long do you anticipate your argument on the matter that we have to take up?
I think probably 15 minutes, Your Honor.
So we'll allow the recess now. It may be that the recess, ladies and gentlemen, will be a little more extended than usual. We hope you're not disappointed. We'll stand in our afternoon recess.
Before, at the New Canaan house, I don't know if Your Honor is even aware that this occurred, but there was a party at the house where Mr. Doulos was present, the children were there, the independent evaluator was present as well, and there was a sharing of food between Jennifer and her still husband at that time. So that's going to come in no matter what, that comes in. But to suggest that the babysitter should be allowed to say, well, they were arguing, they were screaming, whether or not he at one point while they were still married threatened to take the children to Greece. That has nothing to do with what's going on at the time where an evaluator, within 3 to 4 weeks of the disappearance, had concluded in an 80-page report, which I'll note I have, that says that Mr. Doulos would be the better parent for these children, but he was recommending equal sharing of custody. There's also the case, Your Honor, of State versus Reynolds, where even though the court allowed in a narrow amount of evidence regarding the claim of seeking a restraining order that never was filed, it was only application of itself. None of the affidavit, none of the specifics of it, and the court was required to give a very, very specific cautionary instruction that could not be considered for the truth of the matter. But as I hear what Mr. McGinnis is saying, he wants this all to be about a claimed motive that he was yelling at there was argument going on a few years before, not in the interim. It's not like it was ongoing. 2 years before she filed for divorce. And then everything else went through the court. They were using the court process the way it was intended to. She made claims, they were denied. They were in the process of trying to work out issues such as finances. They were working out the custodial arrangement. Mr. Doulos was seeing his children, albeit at that time there was an order that he had to have an independent supervisor because he had apparently told one of his children, according to the file, and told one of his children to not mention the fact that he had Ms. Troconis moving into the house with her own daughter. And so as a result of that, they had issued an order that he could, for a period of time, that he could only see his children with an independent evaluator present, which was done, which was documented, which occurred on a regular basis. So I'm not suggesting that the state can't bring up that there was an ongoing divorce. Number one, the only thing that Ms. Almeida knows about it is hearsay. She might have read some documents. She might have talked to the lawyer for Ms. Doulos because she didn't testify at that hearing. But again, that's an out-of-court statement, testimonial in nature. Therefore, all of that is both not only hearsay, but it's a denial of right to confront and cross-examine because it was testimonial in nature. That is, for purposes of legal process. And it doesn't matter, it's not this case. It was for a divorce case that was in litigation at that point. Let's see if I've covered, there might be one more point I wanted to make. I think the state was trying to argue that when Ms. Doulos told the babysitter, Ms. Almeida, certain things, I assume he's trying to argue they were some kind of spontaneous, excited utterances, but even the way he explained it just now suggested that she later told her about it, and so therefore one cannot even claim that it happened under the, without the opportunity for contemplation, that it happened suddenly, that it was spontaneous in that sense. And I note that the Reynolds case, it was 2 months, 1 to 2 months after the prior incident, so it's still considered relevant. This is years later, and it did not involve any violence. Finally, and I should mention this, there was a suggestion in one of the documents, and I think by Mr. Doulos at one point had purchased a firearm. Now, when the restraining order was filed, it was turned into the Farmington police. It was never, to anyone's knowledge, ever recovered. It was never returned to Mr. Doulos at any time. I assume, since the state mentioned that, there's no intention of trying to elicit that, because there are several cases, when it comes to State versus Gerolamo from the mid-'80s, I think, that said that any mention of a firearm when there's no evidence of firearms in the case is one of the most prejudicial things that could happen in front of a jury. And I note that, especially in this day and age, where there's all these mass shootings and all these almost daily basis, that would be so prejudicial for that to be blurted out. that there'd be no way, short of a mistrial, that that could be remediated at that point. Finally, there's no such thing as transfer motive. So even if this arguably to a minimal extent and with a very truncated offer of proof was admissible against Mr. Doulos, there's transferred intent is if I throw a rock and I'm trying to hit victim A and it misses and hits victim B, there's a transferred intent in the actor to the second victim. It's not reciprocal, however. It doesn't go to another person who's standing to the side. It's just not relevant. And it certainly can't be used because it would even predate the allegation of a conspiracy or anything of that nature, and therefore there's no way to attribute that knowledge and those specific incidents to Ms. Troconis under any circumstances anyway. The fact that the divorce kept going is one thing. The fact that she said in her statement to the police that it was like, I think the term is years of hell, doesn't mean that the specific acts of misconduct, of alleged acts against Mr. Doulos then can be applied to Mr. Troconis. I'll just mention very briefly, there's been some suggestion that it goes to state of mind. Whatever the state of mind is of Jennifer Doulos is not covered in this case under either 8-3 subsection 2 or 8-3 subsection 4. Telling her that I'm going to be taking a certain vehicle to New York, for example, although not particularly prejudicial, is, I'm only raising it because that's.
It's over, listen.
Hear what Mr. McGinnis is saying. He wants this.
Just take up the next witness. Tomorrow morning, take up the quarter argument.
That's fine with the state judge. I'll just familiar with the case. It stands for that proposition. I'm obviously
where even though the court allowed in a narrow amount of evidence regarding the claim of seeking a restraining order that never was filed, it was only application of itself. None of the affidavit, none of the specifics of it, and the court was required to give a very, very specific cautionary instruction that could not be considered for the truth of the matter. But as I hear what Mr. McGinnis is saying, he wants this all to be about a claimed motive that he was yelling at. There was argument going on a few years before, not in the interim. It's not, it wasn't like it was ongoing. 2 years before she filed for divorce. And then everything else went through the court. They were using the court process the way it was intended to. She made claims, they were denied. They were in the process of trying to work out issues such as finances. They were working out the custodial arrangement. Mr. Doulos was seeing his children, albeit at that time there was an order that he had to have an independent supervisor because he had apparently told one of his children, according to the file, had told one of his children to not mention the fact that he had
substantially less probative than the allegation that he murdered Ms. Doulos. I did not mention a gun. I did not mention a restraining order in my argument. I tried to keep my offer of proof to what I intend on showing through this witness, and we spent an inordinate amount of time talking about things that weren't part of our offer of proof. I'll also just indicate, Your Honor, that when the defense said that if hearsay is admitted, any other hearsay from that person.
Yeah, I'm done with this case.
I'm not familiar with the case.
Thank you, guys. Thank you, everybody, for coming. Thank you, Sean B. Have a nice day.